What is up? Welcome to Defense Diaries. I'm your host, Bob Mata, and this is our continuing coverage of the people of the state of Indiana versus Richard M. Allen. Day 19. It was a busy day. It was a very, very busy day. It gets so busy, and I have a relatively decent-sized Twitter account, and in the morning, I always like to send my update. And then we got a break today and it ran out and I was trying, I had 2 minutes before I had to go back up in there and I made a typo on my twit. And everybody's like, what? Betsy Blair, I thought she said there was a car. There was definitely a car there. So I'm going to give you the kind of the overview of what happened today and the way that I've decided to do this today, because if you're not living under a rock and you've heard anything about what happened in court today, you are aware that the defense's forensic phone data expert got on the stand and kind of blew minds in there. So it was one of those events that I think that we should talk about that first and work our way backwards. Let's start with the kind of the most mind-blowing aspect of this. And I think that would definitely constitute talking about that particular expert first. But the overview was as such. The first witness was a lay witness, eyewitness, out on the trails that day. She was called for the second time, the first time by the defense, and that is Betsy Blair. She was called initially. She was not on the stand for a very long time. She was on the stand for, I'd say, 15 minutes. The next witness that was called was a Dr. Stuart Gracian, who, and I had tweeted about this. His CV is unbelievable, meaning it's magnificent. Like he's master's level. He went to Harvard Medical School. He then decided, you know what, I'm going to get a Juris Doctorate, which is a law degree. He's board certified in psychology. He is an extremely impressive gentleman. He's, I'd guess somewhere in his 70s, if I had to. He was very dapper and very learned. He was both of those things. And I found him to be very informative. And his topic of conversation was false confessions. So we definitely want to hear about that. We definitely want to hear what he has to say. And I have to say that in terms of the experts, the defense does a pretty good job of not belaboring points. These experts aren't on the stand for 2 hours. They get them up there, they go through their CVs, they get their experience out there, and then they dig right in. They're like, this is, hold on, let me clear my throat. I've got a frog in my throat. It's because I sit there not talking all day, so my voice isn't warmed up. And then I jump in the car, and Alice and I are screaming at each other. She's like, "What happened?" And I'm like, "This is what happened." And I'm like, I can't read my notes. Did the jury ask questions? So I'm always, so my voice isn't warmed up. So I always have to warm it up throughout the course of the live. So Gracian was phenomenal. And again, his topic was obviously the false confessions. And the false confessions, uh, it was a very interesting, direct, and a somewhat interesting cross in terms of trying to rebut what he was saying, which didn't land with me because of how McClellan tries to label Richard Allen's confinement conditions, where instead of just admitting that it's solitary confinement, he says, "Well, he was in a one-man cell." It's it's like splitting hairs, but it's really a labeling thing. The end effect of the fact is that he's alone all the time. And so it's interesting. The next witness called to the stand was Dr. Aaron Warren. He was their firearms examiner expert. He had reviewed all of Oberg's written notes, all of her everything that she testified to. He did not do a physical examination, which Luttrell was doing the cross examination on that. And Rosie, as I said, he does all the technical stuff. He does like everything science related aside from the phones. That's always Jennifer Auger. She is definitely the phone lawyer on the defense team. And then you've got Brad, who handles, like I said, the guns and the confessions. That's Brad's foray right there, for or forte rather. Sorry about that. And then so it was interesting. Andrea and I had a little discussion about like the effectiveness of the cross. And Andrea's like, I didn't think it hit at all. And I'm like, I didn't from a lawyer's perspective, but from a juror's perspective, I thought that he made some points just in terms of maybe this gentleman's some of his qualifications and some of the things, because and when we get more into it, I'll dig more into the concept. But typically when you have an expert from the opposing side on, you're always going to do your research on that expert. You're going to look at other cases that they have testified during those trials. You're going to look and see what their opinions are. You're going to pull up articles where they've spoken. If there's interviews on YouTube or they've done interviews anywhere on any other kind of TV shows or what have you, the other side's always going to look for it. And they're always going to look for that expert opining something that is in direct contradiction to what they just testified to on the stand. So, and McClellan was able to do that a couple of times with him. How that hits with the jury is hard to know, but it is definitely one of these things where you're like, all right, I mean, it might hit with the jury. I think that the biggest takeaway for me with respect to that witness were the juror questions. And I'll just lay it out there. Spoiler alert. I tend to think, based on these jury questions, that the jurors found Oberg's testimony to be compelling. I think that is something that oh yeah, here, I'll turn that up. Good. I think that's actually iHeart. There we go. Good call. So like just some of the questions really made me feel like, wow, the jury really thought that Oberg was compelling. I think that they tend to believe that the unspent casing is a match and that it's not junk science. That's kind of where I was, so, but we'll get into it. And then next, after that witness, we then had, I believe she was next. All right, bear with me. Okay. Yeah. Then the fourth witness of the day was Stacey Eldridge, and that's who we're going to start with. And she has an education with a bachelor's of science in computer info systems and a master's in the same thing. And she was employed by the FBI for a period of about 10 years. She was a senior forensics examiner, and then she continued her training after she left the feds, wherein she was really digging into mobile phone extractions, tablet extractions, continuing her education with respect to computer extractions. And she would estimate that she took somewhere in the neighborhood of 110 additional classes and seminars in forensic data. So it was pretty, she's pretty experienced in terms of educational background. In terms of her testimony experience, she was a little light there. She has only testified 4 times, which I think you could take both ways. You could take it as she's really just kind of like a science nerd, that like researching and digging in, and that's really her thing, and that she's not as much of a hired gun. I guess how you take it as a juror just depends on your outlook. Maybe they give her more credibility because she isn't a hired gun and she's not constantly testifying. So that's something that you have to take into consideration, because remember, at the end of the day, what we're trying to figure out as observers of this thing is, how are the people that matter in that courtroom in terms of being the triers of fact, how are they taking things? Are things landing? Are they making the points that they're trying to make, whether it be the state or the defense? And, and again, as I was saying it last night, and I've said it during many, many of the lives, I think that like a really big takeaway that we can really kind of hang our hats on are these juror questions. The juror questions are so insightful. They really are. And it really does show you, like I said, with the tool guy, the tool marking guy, I came away from that with the distinct feeling that they felt that Oberg was legit, and that her finding that there was sufficient agreement was legit. So, that right there lets the defense know, wow, we've got a problem there with that particular issue, because frankly, that's the only thing that they really have that's substantive evidence linking Richard Allen to the crime, because all the other, like the only thing that they have other than that is the van aspect, right? That this is like, we got the confessions, and really, I think everything's a toss away, throw everything away regarding the confessions, other than the fact that he's got this one confession that Monica Walla wrote down. Again, that confession is not something that Rick Allen said to somebody else, his mother or his wife, Kathy, but instead, this is something that Monica Walla wrote down in a weird narrative format, as opposed to just kind of jotting the notes down and then quoting, like, he said this, and then he said this, and then he said this. Instead, she wrote it like a little narrative, which the defense's expert thought was curious. And in light of how much stuff is coming out about Walla and how much she was digging in, and exactly who she was digging in with and when she was digging in with them, like you have to question her. So again, I give a lot of weight to the fact that Walla was digging into Allen's case while she was treating him. I think it's a real problem for the state. All right, so in terms of her 4 times testifying, it was 3 times for the prosecution and 1 time for the defense. And at that point, when she left the feds, like I said, she was at the level of a senior forensic examiner. And she continued after that, where she was basically teaching. She was a instructor for digital evidence instructor, still when she was with the feds. So she was doing a lot of that with a lot of the different agents coming in. So she was kind of like when they'd get into that particular field in the feds, she was the one that was teaching the classes. So she's definitely learned it. She's definitely she's definitely got the knowledge base behind her. She's she really knows her stuff. So you head into it with kind of that knowledge base. Now, currently, she's got her own business where she does consulting, and I think she's been doing it for a while. And she's also an adjunct professor at a couple of different colleges. And then she does the forensic examination of digital data privately. That's kind of like her bag these days. So then the defense, which I always like when they front this, because it's a move for both sides, but typically for the prosecution with respect to the fact that she's hired. She's a paid expert, and Auger is great about getting this out. Like she does it with all of her experts. I don't necessarily. I think Brad may have done it with his. I think he may have done. I don't know if he did though. When we get back to the notes, Stacy always asks, "Okay, so when did we retain you, and how much do we pay you?" And she says, "You engaged with my services, and then my hourly rate is 400 an hour. However, in this case, I'm doing it for 300 an hour." And she said, "Well, where does that hourly rate fall?" And she says, "It's kind of in the middle. There's definitely some that charge higher than me, and there's definitely some that charge lower than me." And then she says, "So in terms of your work put in, how much time did you put in this case?" And she says, "Well, in terms of my examination, I probably put about 65 hours in, and then another 15 hours in terms of prepping for trial." And then she asked her, "Well, what did she review?" And she said, "Well, I reviewed the extraction data, which was the first extraction was done by Brian Bunner of ISP, and that was done on, I believe, on 215. And then she also reviewed celluloid extractions. She reviewed Chris Cecil's reports and all of his appendages. And then she also reviewed depositions." So Jennifer then kind of goes through the process of explaining, like, the basics of the examination and the extraction of data from cell phones, kind of like relearning or I guess, educating the jury as to what an extraction is. Because if you kind of think back to both Bunner and Cecil when they testified for the state, I wouldn't consider either one of them learned. I mean, they've received some training. I mean, whatever level of training they had, it certainly didn't compare to the defense experts. I mean, if you were to look just at the CVs, the resumes of the experts on both sides, certainly the experts on paper appear far more educated and far more learned than the experts from the state. But, I mean, that and a nickel will get you nothing because it all depends on the jury. You know what I'm saying? And it's like, you guys kind of know what my position is with respect to expert witnesses. I've told you, I think many times they X each other out. Sometimes they don't. I mean, like I said, I came away from the jury questions to the defense's toolmark guy with the distinct impression that they felt that Oberg was legit and that they definitely were of the mindset that her findings were legit with respect to that being a match to Richard Allen's gun, which is like a big peek behind the curtain in terms of where the jury's minds might be right now. So, which kind of made me want to get to this first because I think that this will probably end up dominating the chat in terms of trying to figure out, well, what the hell? Because it's kind of a mind blowing thing. So she then says, when you conduct an examination, is it just like looking at the pictures and the emails and the text, etc.? She says, no. What I do, she's like, that's kind of looking at she's like, that's looking at the car itself. She's like, what I'm doing is I'm looking under the hood. So I'm trying to see the things that the phone user cannot see. And then she asks her, okay, well, there was a lot of software used by both the Indiana State Police and yourself in this and the feds back when they were allowed to look at the phones. She says, yeah. She's like, as far as I know, Indiana State Police use Cellubrite, and they use that to extract the data off the phones and then to examine it. They also used the Axiom, and they also used a program called iLeap, which she said I'm not very familiar with. And she said that there were a couple other programs that she wasn't real familiar with. I'm trying to harken back. I think I want to say it was Greyhawk. It was something like that. I can't remember, from Cecil's, and I don't know which notebook it was in. But he used a couple of different things that she didn't name. She's like, I'm not familiar with them. She said, as far as she goes, her primary software is Axiom, and then she uses this DB browser for SQLite, and then this forensic browser for SQLite are her main tools that she uses. And then she says that you can extract and show data a little differently, because she was asked, well, what's the difference? And she's like, well, they all have little tools that are a little different from one another. Some work with some phones better than others, or, it's brand specific. And she says, basically, I would attribute it to the fact that it's a competitive marketplace, which is true. I mean, all of these companies that are making the software are hoping to get every single law enforcement agency in the country using their software, because those are obviously big contracts, right? I mean, that's how you make the money. So they're all, it's very competitive, and they're all trying to one up one another. And so it doesn't surprise me that there's a lot of different programs out there. And so then she starts with the basics. She says, well, what's an extraction? She says, well, an extraction's pretty basic. It pulls all the data off the phone, and you save it onto, either into a computer, or you can save it onto a dummy phone, depending on what you're extracting. You need a wiped phone that has nothing on it if you're extracting the phone and you're saving it onto that database. And then when you run the software through it, you're going to obviously run it through the computer. And then at that point, you're going to have, it's going to generate an initial report. So she says, the problem is that with extractions, that every time that you power up and power off the phone, you're losing data. You're going to be losing some data every single time. So the hope is that when you are extracting, you want to try to extract the most that you can the very first time that you turn the phone on. And you lose some pretty significant stuff, which is the problem. And frankly, what they lost here in terms of the data was pretty substantial, especially when we get to the concept, was the phone powered down, and was it powered back up? Because we know there was the bunner when he had to plug the phone in, and he got it to power up on the 15th, and then he did his extraction, but I'll get to that. But then we know that he extracted it again on the 17th, which means he had powered it down and then powered it back up. So he's losing important information, namely that data, because every time you power up and power it down, you lose all that data in terms of that log, the powering up, powering down log. It disappears, it resets. So that's not something that stays in there, even in the Knowledge C database. So she then goes on to say, as far as Cellubrite extractions, what are the extractions that you're aware of? And she said, well, the absolute best is the full file system extraction. And that gets all your user logs, all the user files, everything under the hood comes in through that. It's the absolute best thing that you can do. Now, if you remember back to Cecil's testimony, he unfortunately was not able to figure out how to do the full file system. No, I take it back. Bunner was the one who did the first extraction. So when Bunner first extracts it on the 15th, he does the worst of the three. There's the full file system extraction, there's the advanced logical, and then there's just the straight up logical. So in terms of it, best to worst, you got full file, advanced, and then the worst being logical. When he goes in, um, he just does the logical. Okay. So obviously at that point, the best practice would have been to try to get the full file system extraction. And that sometimes can take several attempts. She said, it's not like she's like, these are phones. They could be finicky. Sometimes you're able to get things and sometimes you're not. And sometimes you have to make several attempts before you get the full file extraction. So, that's always something that you have to take into consideration. And then, so in February 17, Celebrate. So then Auger asked this question because Bunner had claimed on the stand that the full file system extraction was not available in February of 17. So Auger wanted to make sure to get this point out that Celebrate had the ability to be able to do a full file system extraction back in February of 17. So Bunner was incorrect about that. And so finally in October, that is when the full extraction was finally completed. And again, then Auger says, well, what are the problems with the fact that he wasn't able to get that full file extraction on the first extraction and the first time that he powered up the phone? She says, well, the phone is turned on and off. It's turned on and off in February. It's turned on and off in September. And then it's turned on and off in October. And also, not only do you lose that type of the current power log in terms of when it was turned on and off, when it powered up and powered down, but as the phone ages, other files are lost. So there's a lot of lost data there that you can never get back. Like, it can extract everything in terms of things that you think that you delete, but it's not going to be able to extract things that are permanently lost. So at that point, she says, in your estimation, what was lost? She said, well, the current power log that only stays with it until the next on-off cycle, and that she has no idea when the phone was shut off on 214 because that log was lost. So it's like they're sitting here not being able to say, this is when the phone was powered down, or if the phone was powered down on 214, which, as you see, when we get to the end of this, when we get to the big thing that comes out, it's obviously, it's a problem that information, because if he would have done the full extraction the first time, the full system extraction, we would have had that information. You see what the problem is there? So that's why it's an issue. So then she asks what Stacy's process is, Stacy Eldridge, and she says, well, there's two main priorities in terms of what you guys wanted me to do. So you guys wanted me to figure out what was going on with the Apple Health data. Okay. So I was definitely digging into that. And then you also wanted me to try to figure out what was going on to make the phone turn on at 4:33 a.m. Like, those are the two things that you guys were like, what's going on here? This is what we need to know. So that's what her focus was. So then Ajay asks her, did you download the Knowledge C database? And she says, yes, I did. And she said, well, what does that do? She says, the Knowledge C database, what it does is it tracks what you were doing on the phone, the user, and what the phone was doing at the same time. It's very insightful as to what the user was doing while they're operating the phone. So if you're opening apps, if you're closing apps, if you're taking photos, if you're texting, all of that is kept in the Knowledge C database. And she made the point that Apple is very secretive about their secret sauce, and as I was sitting here and I'm like, man, it's like when she's talking about extractions, then you have to run it through, kind of the software to decipher what it's saying. But even then, that there's still language that'll show up on the extraction report that she says, like, sometimes it'll show up in the extraction report as a blob. It'll say the word blob. And then what I hope is that I can change that blob to text so that it turns into hopefully some terms of like human language. And when she said that, like human language, I'm like, man, it's like this is like seriously like alien technology. I couldn't help but think, I'm like, this is like there's entire industries that exist out there that are literally built around trying to figure out what the hell is going on in these phones. You know what I mean? It's like they're having to try to reverse engineer technology that wasn't made by humans or so that's how it feels to me. It's beyond coding. It's beyond coding. It's not like just ones and zeros. It's something like this concept that all of these companies exist and all of these forensic scientists are working on this, trying to reverse, just kind of reverse like what is going on in those phones in order to try to figure out what the hell is going on with them. And it's super competitive. It's just one of those things where they just really don't know. I try to think of like an equivalent of it, but I can't really think of anything. Like what exists out there. Yeah, I mean, ultimately, AI is going to be what's up. I mean, like either AI is going to be like, oh well, I could tell you what's going on, but I have to kill you because it's alien technology and so is AI, or it can give us the answer at some point. It seems like if we're thinking about AI, that it would be a relatively simple task for it to be able to crack whatever algorithms or secret sauce are in these different phones. You know what I'm saying? It's like it's strange to me. It's strange. Like, is there just a group? I mean, I can't imagine what the NDAs, the non-disclosure agreements, are like for Apple, like that company. Like they must be psychotically thorough. It's like if we hear you talking about what we're doing in here, we're going to send you to Siberia or worse. Like it's got to be that kind of thing where like the whole world outside of Apple is trying to figure out how the hell their phones work. Like we have heard experts in this case. I've heard experts in all kinds of cases, and no expert can accurately explain how Apple Health data tracks steps. Like no one can explain it. Like no one. I've found no one that can explain it. Not in trials, not with experts, not online. Like no one knows. I mean, we all know there's like some kind of gyroscope in there and it's somehow based on movement, but it's crazy to me that somebody can't figure out like what the technology is in there that is keeping track of our steps and our health data. It's crazy to me. It blows my mind every time I hear it. I'm like, I don't know. It just makes me want to get rid of the phones. It's like I'm convinced that aliens just try. You guys ever see 2001 Space Odyssey, old movie? It came out in like 68 or 69, maybe 67. Way ahead of its time. And it's like when the apes, it starts with the apes and pre-human, like, so this is the time of apes, and this monolith just appears, this big black slab just appears, and the apes are all wandering around, and they're kind of, they yell, they get loud with each other, and they're territorial, and they don't, they're all just kind of walking around not knowing what to do. And then one morning, like after this monolith has been there for a few days, like one of them touches the monolith and like this thing imparts knowledge on this ape. And like the apes had not figured out the concept of being able to pick up one of these bones from these animal carcasses that are laying all over that presumably they had eaten. And he uses it for the first time to as a weapon. So he hits another ape on the head, and he's like, "Oh my god! I have a weapon." And like all the other apes are like, "What just happened?" It's like that's kind of what this thing reminds me of. It's kind of what this thing reminds me of with the whole phone thing that nobody can figure out what the hell's going on inside of them. It's weird to me. Sorry, it just is. If you guys don't think it's weird, that's on you because I think it's weird. No, it's not a Gen X boomer thing. It's not a boomer thing. It's not a boomer thing. If it were a boomer thing, if there was somebody who could explain it and I said I didn't understand it. What I'm trying to tell you is even all the Gen Zers who are all the tech people, they can't figure the shit out. So what now? So like I reject that whole boomer thing. That whole boomer thing is rejected because the Zers aren't able to figure out what's going on the phones either. And I'm Gen X anyway, so like firmly Gen X. Like I invented Gen X. So boom. How about them apples? All right, let's keep going. Sorry about that little side note, but it's just strange to me. Every time I'm like watching these trials, and like even when our phone experts could never like, I'm like, dude, can't you explain anything? Like you don't really have an answer. It's like you use a bunch of techie words, but you're not giving me the answer. Like dumb it down to me. Like tell me in like I was 5 years old, like exactly what happens. Like how did this happen? Like is there, and it's like they never have answers. They never really have answers. So she says, she asked her, "Did you download the knowledge C?" She says, "Yes." And she said everything was pulled from the actual extraction. So what she was using was Bunner's initial extraction. So she did not physically get her hands on the phone and do her own extraction. Now, that was the first thing, that was the very first thing that Allison was talking about. It's like when I called her, she's like, "But did she do her own extraction?" I'm like, "No, she didn't do her own extraction." I'm like, but like the way that it works, it's not like where you'll have the issues like we'll hear about with the firearms, the firearms, the tool marking guy. His issue was that the jury kind of took umbrage with the fact that he didn't do his own physical examination of the unspent casing and the weapon. With this, when she says she's looking at the extraction, she's actually physically able to go into the extraction. So they're sending her the extraction on a thumb drive, and she plugs it in, and then she's able to access it. So she's able to get in there. She's able to see the whole extraction as if she had extracted it herself. No, but Allison's like, well, yeah, but she can put in different parameters. And there's different things that she can look for. And I was like, true, true. But I mean, she didn't do that. And again, I just want to remind people in terms of what the defense can do in terms of hiring experts is limited to the funds that they have available for experts, right? I mean, so like I kind of had wished that there was a way for them to be able to get in, especially with the gun guy, like, hey, you didn't do the physical examination. Is there a reason aside from you didn't ask us to do it or you didn't ask me to do it? It would have been like, yeah, you didn't have the money to pay for it because you had to pay for a bunch of other experts and you had a limited budget. Like that's the reality of it, you know. But like you can't really get that in terms of like just nuts and bolts saying it. So she says that everything that was pulled from the actual extraction, the initial extraction, and then she enters in defendant's TTT, which is the knowledge C database examination. There's no objection; it's admitted. And then she also says that she asked you examined Cecil's examination report, correct? Which is something that we entered into evidence back in the day, back during the state's case in chief, which is defendant's exhibit P. And she says, yes, I examined both those things. And then she said on August 18th, the report was reviewed. And we know that that is the date that Cecil created his new report based on his last extraction because Cellubrite had updated their software. At that point, the judge on her own accord asked for a sidebar. They went back. It wasn't lengthy. And then they came back. So at that point, Auger moves over to the screen and they start going over a couple of the different frames of the knowledge C database. And she says, okay, well, what are we looking at? And she's like, well, this is a screenshot of the knowledge C database. You can see here, it shows that there are certain apps that are open, gives the date and times that they're open. And she says that you'll notice that it looks very similar to an Excel spreadsheet, but it's got a little but it's got a little bit more bells and whistles than your typical Excel spreadsheet, but it looks very similar to an Excel spreadsheet. So she says, okay, well, we're gonna go. She's like, I want you to go all the way to the right. Okay, so she's like, okay, and so Ajay's working it, and she pulls it over because she's working from her laptop, and obviously the screen is mirroring whatever is on her laptop. So she pulls it all the way over, and it's the furthest column to the right. And she says, this is the Z metadata. And she says, okay, well, I want you to explain. I look here and I see that it says, in this one dialog box, it says the word blob. She says, yeah. She's like, that's something where when you're looking at Cellubrite, and if it doesn't have a way to be able to decipher it, it will just put in the word blob. She says that I have the ability to be able to change that to text to see if there's anything that's in human language that I can make out in terms of what it's looking at. And so she says, okay. And she's like, now I want to turn your attention to Defendant's Exhibit P. And this is, of course, Christopher Cecil's timeline, the Indiana State Police, their forensic phone data guy. And so this is his timeline. And she says, it's true. Are there items that you agree with? And she says, yes, there's generally items that I agree with. And there are some things that you do not agree with. And she says, that's right. There's some things that I don't agree with. And she says, well, let's start with what you don't agree with. And she says, well, I don't agree with some of the dates and some of the times of some of the messages, meaning when they came in. And so at this point, she kind of goes through the whole concept of the iMessages, right? We heard that with Cecil on the stand. The concept being that iMessages are distinct to iPhone users, and iPhone users have the ability to go through the Apple server to wherein we can avoid normal text fees through our service provider because we're not going through their towers or their system or their servers in order to get text messages to one another. So SMSs. And, that was Apple's workaround. They're like, okay, well, we're going to make this tasty little thing for our users where if you've got two Apple users, they can message each other without having to pay for it, especially if they're on Wi-Fi. So they have that discussion, and she says, that during the afternoon of 2/13, it appeared to her that the phone was dropping the signals. It was on and off the tower, during the afternoon. She said that, that's something that I agree with Cecil about, that it wasn't steadily connected to the tower, that it would fall off and it would connect again, that was happening. And then she says, okay, well, let's look strictly at the timeline. And she says, as far as the data that you were able to look at, when is the last time that you saw Libby's phone connect to the tower? And she says, well, that was at 5:45 p.m. on 2/13. And she says, okay, so that's the 13th. She said, did you locate a time that it connected on the 14th? And that, she says, well, yes. She says, I saw that it connected to a tower at 4:33 a.m., which we all know about. So that's not news, right? So that's 4:33, as we know, when the flood of 15 various types of messages all kind of flow in. And then she asked her if she had reviewed the pings that had been sent by AT&T, and she also reviewed the location data that had been sent. And she said, yes, I did. And she's like, were you able to get any information from that? She's like, not really, in terms of this question of what happened, why was this phone not connecting during this 11 hours? It's the question that I'm always wanting answered, right? It's the question I think many of us want to have answered, which is, why does that phone not connect for 11 hours when it's right there? And people have opined many things. Maybe the phone was wet. Maybe it was, it was drying out and then it turned back on, and that's when it connects, so like no one really has an answer for it, like still. And it, like, spoiler alert, she doesn't have an answer for it either. She doesn't really know either. Cecil didn't know and she doesn't know. So then the next thing that she's looking at is she says she goes to AT&T, who is the carrier for Libby's phone, and she looks at the historical precision location data. And she says, "Why are you looking at that?" Nick says, can I ask some preliminary questions?" And then he says, "Is this the entire log that we're looking at?" And she's like, "No, this is like the date in question. I'm looking at the date in question." And he says, what training have you received to read these logs? Have you ever taken a course, um, ever, with respect to, reading these logs and deciphering what you're seeing?" And it's like, she's like, "Back when I was in the feds." And he's like, "Okay, well, and she's like, I've seen it in seminars and, in these different courses that I go to, and, in discussions with my colleagues, we talk about these precision location logs, or the historical precision location logs." So she's like, I feel that I'm confident in terms of looking at it. So he says, "Okay, well, you haven't had any formal training since back when you got trained by the feds in 2009. She says, "I mean," she says, "that's true." She says, "That's true. But, I continually am trying to learn things." And so he says, "Well, have you ever worked for AT&T?" And she says, "No." And he says, "Okay, well, the state objects. Number one, it's not the complete log. And number two, I think that the rule of completeness would bar her from being able to get this in. And additionally, I don't think that she has the expertise to be able to testify as to, the data on this particular log." So Ajay's like, "Well, the reason that we didn't put it in is because it's hundred of pages, and we focused on the date that matters, which is, the 13th and the 14th. And if Mr. McLean wants to put it in on rebuttal, he can do that. He can put the whole thing in with a bunch of dates and times that don't matter. But, we were trying to focus on the task at hand here, trying to figure out what happened on 13th and 14th. And as far as training, she asked a question that, and I'm talking about Ajay. She said, in terms of the form that the data is in, has that changed at all since the time that you received the training?" And she says, "No, it hasn't changed. It looks the same." And many of the seminars that I go to discuss it. So the judge allows it in. It's very tense. It's like with the state stuff, she pretty much lets it in. I mean, the one thing that I can remember that she didn't let in that I thought was significant were the series of four photographs of Rick Allen in or around 2016, wherein she denied that request to allow that in. She sustained the defense's objection, and then they ended up getting those pictures in through Brittany yesterday. So, but with the defense, you're always on pins and needles as to whether or not she's going to let stuff in. Like, they're always worried about it. Like, they're always like, "Oh my God, I don't know if we're going to be able to get this in." And it's like, and then you have to roll with the punches when she doesn't allow them to get it in, So it's like, it's tough. It's tough to do. It's tough to do as an attorney. It really is. So at that point, it's admitted over objection and it's published to the jury. And then she says, "So what does the historical precise location data tell us?" And she says, "Okay, well, it tells us that between 5:44 p.m., the last time that the phone is known to have connected to the tower, and 4:33 a.m., the date and the time, that those are the two last. It's the date of the last connection. It gives us the longitude and the latitude." And then she goes into connection times, that talking about GMT. When you're using Greenwich Mean Time, just as a rule of thumb, you subtract 5 hours, or they can use UTC. She says, well, what does Apple use? She says, does Apple use GMT? She's like, no. She's like, cell phone records are like they're all over the place. She's like, it's a wild array and they're all in different formats. She says, like, Apple uses this crazy format starting from January 1st of 1970. So, so she said, okay. She said, but let's keep rolling. And so she said, all right, so I want to look at two items. So she says, item one, the last connection on the date of 213 or on 214 of 17 is what time? She says that is the 4:33 a.m. She said it actually showed up as 9:33 a.m. Greenwich Mean Time, but I knew that we had to subtract the 5 hours, so that puts us at 4:33 a.m. And she says, okay, and item two was a connection, the last connection known on 213, and that she said was 10:44 GMT. So subtract your 5 hours, that's the 5:44 p.m. That was the last time that we see the phones connecting. And so then Auger asked, was the data on the phone, or was there data on the phone that said that the phone did not connect between these two times, between 5:44 and 4:33? And she says there was no data that she could find on the phone that said it connected between those two times. So then she pivots over to Cecil's timeline. She says, does it show iMessages coming in between 5:44 on 213 and 4:33 on 214, or on 213 and then on 214 at 4:33 a.m. She says, well, the iMessages, it shows that between the Apple users, or if they're on the Wi-Fi or if they've hit the tower and they go through the Apple server, and according to the timeline, she saw the last messages coming in were 4:51 p.m., 4:52 p.m., 4:53 p.m., and 4:55 p.m. And then she said she found a voicemail that was time-stamped at 6 p.m., but she's not exactly sure when that came in terms of the date. But that voicemail, when she ended up finding it, that didn't show as received on the phone until 2:17, which would have been the second time that Bunner turned the phone back on in February. But she said, but you can tell when the voicemails were left. And she's like, yeah, I saw that the voicemail was left because it was time-stamped at 6 p.m., but it didn't get to the phone until 2:17. And then she says, well, can you explain to the jury what a cell phone ping is? She said, it's a pretty simple concept. It's basically where one tech device sends a message to another tech device. Hey, are you there? And then if it is there, it'll say, yeah, I'm here, ping. And then if it's not, it won't. And then she said, she asked her, how are pings different from a cell tower, like a straight up cell tower connection? She says, well, the pings are sent purposefully and they're sent directly to the phone. So, and we know that AT&T was repeatedly trying to ping the phone until it finally was able to ping it at 4:33 a.m. And then she asks her the question, do you have an explanation why the phone in that entire period of time was not able to connect to the tower? And she actually forgot to ask that question. And then she went back to it before she jumped into the Apple Health data. So she asked that, Jay did. And she says, I really don't have an answer. She's like, I honestly don't know. I don't know what could have caused that, which was the same answer that Cecil gave. So at that point, she pivots over to Apple Health data. And then this is where she says that only Apple knows the secret sauce of how it keeps track of steps and all the different things, how many floors you've walked, or if you've walked steps, or, your topography. It's like nobody really knows the technology. Like, we've done so much research on it. She's like, Hague went out and they tried to figure out exactly. And she's like, Hague is pretty well respected as like the preeminent researcher out there, and they're over in Europe, and they're trying to figure out, not Europe, I think she said wherever Hague is. I forget what she said. Um, and she says, well, you know, in terms of the phone itself, the device itself, there's no evidence on the phone of what happened in terms of why it didn't connect. And she says, no. And so Ajay asked, well, is it possible that it could have moved? So like she pivoted back again to the fact that the phone didn't connect between that 11 hours. And she says, yeah, that I mean the phone could have moved, or it could have gone into a vehicle. And at that point, because it's like that's always the big debate. It's always the big debate as to whether or not if a car, if a phone is in a vehicle, in particular an iPhone, will it keep track of steps? Now, I personally, and I'm sure all of you guys that have iPhones can attest, like, and I've talked about this on a live before. I mean, I've had the situation where I've been out walking the dog, and we're like, coming back, and I'll forget to stop, even if I'm keeping track of my steps, like if I'm doing a workout, so I can keep track of how long me and the pup walked. And it's like, and I'll forget to turn it off. And I always kind of know, generally speaking, like what my laps around the off leash park is, and like how much it, like in terms of miles, it typically is. And it's like, well, all right, I'll get home and I'll look at it, and I can see that it has clearly kept track of the drive. But it's rare. Like most of the times when I forget to turn it off, which is a vast majority of the time, I forget to stop it. It's a vast majority of the time it's not keeping track of the driving. So like the best guess out there in the whole forensic phone data world is that it sounds like if you hit a bump, a series of bumps, it can fool the phone into thinking that you're walking. Now the question becomes, is that, like, does it keep track once it starts? It hits a few bumps, so then it's like, okay, well, this person's walking, even though there's not bumps beyond that. Do you know what I'm saying? Like if it doesn't continually bump, once it locks into like, okay, this person's walking, is it then tracking based on GPS data of the distance that's been covered? I mean, that's just one of the things that nobody knows definitively. And it's going to be a big deal in this case. Like ultimately it's going to be something that the jury, in light of what they find out today, it's going to be an issue back in that deliberation room. So again, she says, so what are the different ways that the Apple Health data would stop keeping track of the steps? She's like, so the phone could have moved, but it could have moved in a vehicle, and it didn't keep track of the steps. The cell phone signal could have been lost. Obviously, the phone could have been turned off. Or, if you think about when you get in an elevator, um, that would be a way that you would disconnect from the signal as well. So metal are different ways that she opined that you can lose a signal, uh, like a tower signal. And then she talks about, in terms of the motion from the Apple Health data, what is the most accurate? And she says the steps are definitely the most accurate. As a matter of fact, like distance can be sometimes very inaccurate. It can be 40% off sometimes on distances. So, the steps are what they rely on the most. And then she asked, well, as far as Cecil's report, as far as steps and distance, are you in agreement with his report? She says, yeah. I mean, in terms of the data that I saw on the extraction report, I am in agreement with it. And then, hold on, I'm gonna check these notes. All right, so then we have at this point she starts asking her, she's like, is there a way that the phone can move without logging steps? And she says, yes, in a car, or yes, if the phone's turned off. But again, I mean, the problem here is going to be that because that data was lost, we'll never know if the phone was turned off. Now, when we get to the new information from the defense, it would seem to indicate that the phone could not have been turned off because I'm assuming that the data that I'm about to disclose to you that came from the phone would not be tracked if the phone was not operating. So she says that so then she's about to get to the big stuff. So she says, was there any data shown after 5:40 p.m. on LG's phone? And she says there was no data showing that it was operating. So she's like, she can't say definitively one way or another if the phone was operating after 5:44. There's no data on there showing it after 5:44. And then she says, okay, I'm going to I'm going to direct your attention to 5:45 p.m. on 2/13 to 4:33 a.m. Can you tell me? And she puts the screen back up. She's like, can you tell me what this audio output route is that we're looking at here? And she says, well, she's like, well, she said, before we do that, can you tell me how Officer Cecil described it? And she says, well, Cecil described it as basically that his research is incomplete. Now, this part was a little, this is why I want to look in this other set of notes in terms of what these functions are. So he said there's a series of numbers there where that like this, the number one would indicate that it was a headset. The number two would indicate because it's like, it says audio output route, and then it's got a series of numbers after it. Like I wish we just had the exhibits. It would be so easier to describe this to you guys with being able to put the exhibits up. Maybe someday we'll be able to look at them. But you see the series of numbers, and so she says, "Well, have you been able to figure out what these different things are?" And she says, "Well, one is attributed to a headset. Two is attributed to a headset. Three is a user speaker. Four is headphones. Five is a Bluetooth device." She says, "Okay." And then she says, and again, this comes from the Knowledge C database. This is where she finds this information. Okay. And she then talks about that the research is complete, right? That in terms of Cecil's research, that his research was complete. And then and that was all he had. So he couldn't figure it out. Like Cecil was never able to figure out what this particular item in the Knowledge C database with respect to this audio output route was. Just didn't know. Like he had no idea what it was. So then he says, she asks her, Stacy, did you do research into this? She says, yeah, I did. I did all the research and Ajay says, well, out in the forensic data community, is this research been done in terms of kind of pinpointing what this stuff means? And she says, yes. She's like, it is done. And she says, okay, well, what does it mean? And she says, well, for what we care about, we found out that the number one means that a headset, like one is attributed to a headset. So she then says, okay, can you explain it to the jury what we're looking at in terms of your timeline? She says, okay, on 2/13 at 10:32 p.m., a record was created. And she said that from what I can tell, that this record at 10:32 p.m. means that something happened on the phone, something that was actually recorded on the phone. It's something actually occurring. And then she says, okay, well, can you tell us when that started? When did that event start? She says, okay, well, based on the data that I'm looking at on Cecil's report, that event started at 5:44 p.m. And she said, okay, and then when did it end? And she said, that time that I was just talking about. So this event starts at 5:44 p.m. and then ends at 10:32 p.m. And she says, okay, well, based on the research that's out there in terms of the knowledge C database, and with that, that number attributable to either headphones or an aux cord or something like that, what were you able to find out? She says that it appears that the phone logged in that a headphone was inserted into the phone at 5:44 p.m., either wired headphones, which she was able to view through the text information. So when it said blob, she went into text and it said headphones, wired headphones. And so it was either wired headphones were plugged into Liberty German's phone at 5:44 p.m. And then so she brings an iPhone 6 up to her and she says, "Is that stable? Like meaning like is that a connection that's stable?" She says, "Yeah." So she's like, "All right, I have here some old wired headphones. Can you plug it in?" She plugs it into the phone and then she holds the phone by the cord from the headphone cord and shows that, the thing's it's not dropping right off. It's a stable connection. And so she says, yeah, that somebody took a headphone jack or an aux cord and plugged it into that phone at 5:44 p.m. And then at 10:32 p.m., somebody unplugged it. And so then the next question was really interesting. So she says, was there anything? So she said, well, tell us what happens when you get when you plug something into that port, that aux port or that headphone port. She's like, the sound stops on the phone. So like if you've got music playing and you plug it in because it switches into headphone mode, and boom, like the sound stops. If you're getting a phone call and you plug headphones in, obviously it goes to the headphones. So the sound stops. So she says, what happened at 5:44 p.m.? And she said, well, what happened is within milliseconds before the aux cord was plugged in, there was an incoming phone call. So that was kind of like a mic drop moment in terms of the concept being for the defense is that the phone call came in and the killer is trying to silence the phone call and they plug an aux cord or headphones into it. Like that seems to be the defense's theory. And then so she ends it on that. So, I mean, what do like how do you explain it? Like how do you explain that situation? It's either a situation where, and we'll see in very short order how the state tried, and I need to tell you, the state had no idea this was coming. And they didn't have an obligation to turn it over because there was nothing to turn over. This was something that ISP, Nick McClelland, all of them had because it was in Cecil's report. Like Cecil just didn't know how to read it to see that this has happened. So, and they had no obligation to tell them. And their expert didn't do a report. And if you're ever wondering why sometimes experts don't do reports, this is why. So she didn't have an obligation to do a report. So she ends up, this is a total shock to the state. Like they had no way of knowing it was coming because their guy Cecil or Bunner had no clue. They had no idea. So McClelland starts in and he starts attacking her experience. And that's always the way you do it. That's how you attack experts is you attack their experiences. He asks, what training do you have extracting cell phone data? She's like, well, the data the training that I received back with the feds when I was with the feds for 10 years, and then I've continued to take tons and tons of classes regarding the extraction of phones, tablets, all kinds of devices for the last, whatever it's been, 16 years. Like, it's what I do for a living. So and then he goes into the fact that she's only testified 4 times prior. And like typically when you have testified, it was dealing with computers, not cell phones, correct? She says, yeah. She's like, but I like my last case actually was dealing with a cell phone. But he's like, well, that was dealing with an iPhone video, right? That wasn't the same kind of data. So she's like, yeah, that's correct. And he said, is this the first time testing a cell phone? Um, or is this your first time testifying about cell phone extraction with respect to the Knowledge C database? And she says, yes, this is my first time testifying about it, which doesn't diminish her knowledge about the the Knowledge C database. I mean, either she knows it or she doesn't know it. Now it's going to be up to the jury in terms of how much weight they're going to give that question. If they care about whether the fact she testifies all the time, whether she's a hired gun, whether it be for the state or the defense, whatever, does it matter to them? I mean, somebody's got to testify for the first time at some point, don't they? Either they're knowledgeable or they're not. I mean, I think you're going to base your opinion as to whether or not that expert is credible based on the knowledge that they're partaking. And when you look at her knowledge base in comparison to Chris Cecil's, there's no comparison. I mean, Chris Cecil just doesn't know nearly as much as she does, and I mean, her pedigree is better. So, but I mean, who knows what a jury's going to think? So he then asks, so you just to be clear, you used the primary extraction was from Brian Bunner's phone, right? Said yes. And he asked, did you receive the information about the case? Did you know about any of the facts of the case? And she says, well, I knew some things. He's like, do you know where the cell phones were? Did you know where the cell phone was located? Did you know that it was under Abby's body, under a shoe? And she said, I think I kind of like, I think I was aware of that fact. He's like, were you aware of the geographical location of that phone? Like, did you have that information? Did you go out to the crime scene to check it out? And she says, yeah, I'm aware of where it was found. And no, I'm not. I did not go out to the crime scene. So he's like, so you didn't have any of the geographical data, so you have no idea, like in terms of your analysis, like how hard or how difficult it might be to connect to the tower, and like these types of questions need to be turned back on the state, because the fact of the matter is it's the state that has the burden. The defense doesn't have to prove anything here. When you have to look at like who had control over the phone, who were the ones that should have been doing testing, like drive-by testing, which is where, they basically just drive around and see where phones connect to certain towers. It's like, it's the state who had control of this phone. It's the state who should have been doing this testing, so it's like, you've got to turn that back around on the state if you're the defense, because it's their burden. They're the ones who should have been doing all this shit, not this woman. Like, what is she supposed to go do their jobs? Like, this all should have been stuff that they had on lock, but they didn't have any of it on lock. So he keeps going. He's like, do you agree that the GPS location, as far as when the video was taken on Liberty German's phone, that it changed? So he's going all the way back to this thing that I think that the state pretty effectively dismissed, which was the concept that the video was initially showing that the video was taken at the park. I think that the expert gave a pretty good idea of why that happened. And they were talking about the fact that it really is a battery saving technique, that when a phone first comes on and it's trying to geolocate like a photograph or where it was taken, that initially what it'll do, so as not to suck up a whole bunch of battery by connecting to a satellite, that it will essentially just give an estimation based on prior GPS location, and it'll give a bigger proximity. But within a few seconds, if you keep the picture open, it'll ultimately zero in. And it did zero in to being, on the Mona High Bridge. So like I don't even know why he was going back to that. I guess he was just trying to get that, like if that was still something. And I think he was trying to really figure out anything that he could talk about that had nothing to do with the fact that the defense has now had an expert testify that it appears that somebody plugged something into this phone, either headphones or an aux cord at 5:44, and then unplugged it at 10:23 p.m. on the 13th. So then he says, in terms of the Apple Health data, that was last reported movement was at 2:32. Would you agree with that? She said, yes, I'd agree with that. And so then he asks, okay, and would you also agree that the phone did not move? And she says, well, I wouldn't agree with the phone did not move. I would agree that it did not log any movement. That doesn't mean the phone didn't move, which is it's a distinction, but again, you've got to like try to figure out. So now here's the problem from the defense's perspective as I see it. So the defense, now that they have this information, in terms of they're of the position that somebody plugged something into that port at 5:44 and then unplugged it at 10:23. Okay. Which means that it would only log that information if the phone is powered on. Like it's not going to keep track of that information if the phone was powered down. Now, nobody ever asked the question, neither side ever asked anything about airplane mode. And I was surprised the jury didn't ask about airplane mode. What about airplane mode? Like, is that like, could airplane mode have been like in play here? Nobody asked it. I was sitting there going nuts in my seat. I'm like, why isn't anybody talking about airplane mode ever? So, but as far as the defense's theory, the phone has to be on, right? In order for the phone to log that information that something was plugged in and then something was unplugged. Because we don't have that data. Like it's gone. It's not in the Knowledge C database because of the fact that the phone was turned on and off twice in February, and then in September, and then October. So whatever happened in terms of powering on and powering off, in terms of battery power, is all gone. Like nobody knows. Like all they know is that the fact that the battery couldn't have been dead because the phone connected to the tower at 4:33 a.m. That's where we're left with this thing. So as far as, yeah, I mean, I hear you, but why aren't they telling the jury that, DB? Like, who gives a shit about us? Like, we've got a jury out there that needs the information. And maybe it doesn't, like, and I would expect that there's plenty of people on that jury that are over 60 who truly are boomers who don't know anything about phone tech. Like, if they're anything like my dad, I mean, that dude knows nothing about phone. Like, he can literally text, take photographs, and make phone calls. That's what he does on his phone. That's all he knows. And maybe do like a Google search. He doesn't know anything like that. But so the concept is that the phone has to be on, right? Which means that they can't make the argument that the killer turned the phone off, got in a car, and drove. So I'm sitting there thinking, if we've got a situation where they've testified that one of the things that can cause a phone to stop connecting to a tower is metal, and they gave the example of a elevator in a building, what about the concept, if like I'm the defense, I'm thinking about the concept of a trunk that potentially the girls are put into the trunk of the car, and that the killer would have taken the phone with them up in the front seat, so as the girls can't call for help saying that we've been kidnapped and we're in somebody's trunk, right? So, and they're but like it's either the phone's in the trunk and it's not able to receive a signal from the cell, or it's in the car and it doesn't bump anything to cause it to move. It's tough. It's tough to, nobody asked about a Faraday bag. Nobody asked about that. And if you guys don't know, a Faraday bag is a bag that, like, law enforcement uses them all the time. You stick it in the bag, the purpose being that you want to secure the phone from connecting to anything or having any more data coming in or coming off of that phone before you get it extracted. That's what Faraday bags are. So I don't know. It's like I'm sitting there thinking about the potential of what this can mean, if it means anything. I mean, if the phone has something plugged into it by somebody at 5:44 and then somebody unplugs it at 10:23, I mean, how does that work into the different theories out there? You know? I mean, it would seem to indicate that somebody was there, but are they really sitting there for, I mean, at that point the search was on. So we know for a fact that the searchers, in particular the firefighters who were on the south side of the creek, but were searching in the creek and could clearly see over to where, at least the general area where the girls were discovered, that the killers weren't over there at 5:44, right? So that means that the girls were moved, but how do you move them without the phone showing the data unless it's in a car? And they take the shot to not turn off the phone, and they take the chance that the phone is not going to keep track of the steps of movement. It's like, I don't know. I don't know. It's perplexing. It really is. I mean, the question then becomes, again, the defense doesn't have to prove anything. They have to create reasonable doubt. And so my inquiry to you is, does this kind of information create enough of a conversation with the jury as to what may have happened, that in turn turns into reasonable doubt? It's a really interesting thing to inject into this case at the 11th hour for the jury. It's a legitimate thing. But let me keep going, because when we get to the jury questions, they're pretty interesting. So McClellan keeps going at her. He's like, so at 4:33, would you agree to me? So he's like, he says, earlier in the day, you would agree with me that it appeared that Libby's phone was bouncing in and out of service based on the data that we can see. And she says, yes. And he says, okay, so based on that concept, is it reasonable to believe that the phone continued to be out of service, in and out of service, until 5:44 p.m.? She said, I mean, it's reasonable. It's a possible explanation. And then so he says it would seem to indicate that the headphones were plugged in, that it might register in health data, right? And she says, well, it might and it might not. And then so he said, okay, so there were, a couple of concepts that you came up with how that phone wasn't connecting to the tower. You said like a signal blocker, and then metal from a building, right? Those are a couple of things that you said. And he said, "Can you?" He's like, "Did you see any evidence on the phone that a signal blocker was used?" And she's like, "Not with the data that was available. I didn't." And he's like, "Well, does that exist to be able to tell if a signal blocker was used?" And she's like, "I don't know if like that's data that's included in the knowledge C database." So then at that point, he says, "Well, what about, did you see any evidence that this phone was somehow offline because it was in a building? Like, you don't really have any proof of the fact that the phone moved. So you really can't say with any kind of certainty that the phone wasn't tracking movement because it was in a metal building, right?" She's like, "No, I can't say that." So he says, like, he's like, frankly, what the evidence and common sense is pointing to is that this phone was again in and out of service from 2:32 till 5:44, and then, quite frankly, it just for whatever reason it goes out of service until 4:33. Now, I mean, could that be like, look? I mean, it's well known that the signal out there sucks. At that point, there was one tower, right, and that one tower really is getting like drained when the search party gets there. When you have the search party on the 13th there, that's obviously going to be creating an issue with tower. So, and we know that that goes on until 2:30 in the morning, right? So at 2:30 in the morning, up until that point, is it possible that the phone is not able to connect because it's got a lot of competition in that area in terms of other devices out there? I suppose it's possible. And I mean, is it also possible that, it doesn't connect for the 2 hours after that? I mean, is that possible? I suppose. Seems unlikely. Because remember, I mean, the overarching theme is that AT&T is pinging it. Like, that's the thing that always drove me nuts about this, because it's not as if there was nothing trying to connect to that phone. Like, I buy the concept that at a certain point family and friends are going to stop trying to contact them. I mean, that makes sense to me. At some point, it's about looking for them, because there's no way that at 8, 9, 10 o'clock at night that the girls, if they're alive and well, have not contacted somebody. So that makes sense to me that the calls and texts would have ceased coming in. But the one thing that kept coming in throughout the entire time was the AT&T pings. So that's always been my issue with this is, okay, let's arguendo. Let's assume arguendo that when the searchers are there and the woods and the trails are filled with searchers and they all have their devices and that tower's stretched to the limits, and the phone that is under Libby and there's, like theoretically blocking a clear signal from the tower, that the thing just doesn't connect. But then when all the searchers clear out, AT&T's still pinging the phone. And for whatever reason, it still doesn't connect for that 2 hours, and it finally connects at 4:33 a.m. Now, does that mean like again, the things that I would have liked to see from the state is data about that tower. Like, why aren't they putting any kind of witness in to talk about drive-by testing that were done by law enforcement around that tower? Like, yeah, these are points, these are areas that the phone just doesn't connect. Like there's like, and these are areas where the phone does connect. Like, I mean, they didn't even go so far as to test the area where the girls were to check what kind of service they had with various amounts of people there. Like, do some kind of research. Try to validate what's going on in that area. This wouldn't have been that hard to do. Like, bring one phone, have AT&T as the service provider for that phone, knowing that that's a tower for a different that's owned by a different company, and test it. Walk around that area. See where the signal hits, where it doesn't hit. See where it's bad. Have multiple people there with different phones. See what kind of connection. Like none of that was done in this. It's like once they got the Apple Health data that the phone stopped moving at 2:32, they were like, "We're done. We're good. We know what time the girls were killed. The phone stopped moving, for God's sakes. There can't be anything else." That's how we end up not finding out until 2 months ago, 3 months ago, that the phone reconnects to the tower at 4:33 a.m. So that at that point, we learned that the battery was not dead. We learned that the phone reconnects. We learned that 15 messages come in, and we didn't know any of that. And we're in year 7 of the investigation. So, I mean, you have to hold law enforcement accountable. You have to put it to them because they were the ones in control of investigating. They had the evidence at their disposal. They had the phone. They could have brought out that phone. They had already done the extractions. They finally got in October, they finally got the full system file extraction. Like that was as good as they were going to get. There was never going to be anything better than that. So when they got that in October, they could have felt free to like, all right, stick it in a Faraday bag. Let's go out there and let's plug the thing in and let's see where we pick up signals around here. We got to test some theories. We have to assume the defense, because they knew everything the defense knew, obviously. And they knew about the third party culprit theory. And they knew about the concept that the defense was going to say that the girls were taken off site. They knew all this shit. They knew it from the minute the France thing was filed. Like as soon as they knew that, if I'm the state, I'm going out there and saying, all right, like, because we don't know at that point, if you're the state, whether or not Gull's going to block them from being able to get third party culprit stuff in. You got to go out there, if you're law enforcement, say, we need to test the shit out of this thing. Because we know what they're going to be trying to say. We know it. We know that they're going to be trying to say that the girls were taken off site. We need to disprove that. And we're going to do it right there. We're going to go out and we're going to show exactly how that phone would not connect. We're going to prove it. We're going to go out there. We're going to put something over the phone for 11 hours and we're going to see if it doesn't connect. I mean, do you think that a jury would like to see something like that? I do. Do you think that everybody that's following this case would like to see evidence like that? That kind of testing was done by law enforcement? I do. I don't know. Ultimately at the end of the day. So ultimately, McClellan kind of ends it on that note. He feels like he kind of recovered from it a bit. But again, he's reeling at this point. I cannot tell you how horrible it feels at trial when you're sitting at the table to be surprised, especially by something this significant. I mean, I just want you to try to imagine being Nick McClellan, lead prosecutor on this case, and to get handed this report, which comes from your own shit. Like, this isn't something, remember, the significant part of this is that Stacey Elridge used the extractions that were done by the Indiana State Police. She did not have her, if this would have been an entirely different issue if she had gotten the phone and done her own extraction and the defense did not send them, the state, the report of her extraction, and then they tried to surprise the state with it. Then that would have been trial by ambush. Nick would have been screaming and yelling, "This is bullshit. I can't believe it. This is outrageous. This needs to, there's no way," and Gull probably would have kept it out. But that's not what happened here. What happened here is that she took the extraction from, her extraction was done from the extraction that was done by Bunner, the first one. And then she's also using the extraction, the full system file extraction from October. She's using those too. So she's using those to create her information in terms of this is what I'm seeing. I'm sorry y'all missed it, but it was right there for you. You just missed it. So, but like imagine being McClelland and you're learning this information on day 19 of the trial where you have not had the ability to be able to prep for it. Talking about having to try to think on your feet like that, like there's no worse feeling, and I don't give a shit what side you're on, than getting bitch slapped like that at trial in the middle of it and not seeing it coming, where it's something significant. It's something significant, and it's like, and what happens next is interesting. So Ajay gets up there on redirect and she asks her, she tries to rehabilitate her a little bit. She says, how often in the work that you do are you dealing with the knowledge C database? She says, all the time. It's like the number one thing that I'm looking at these days. It's like it gives us more data than anything. It gives us all the under the hood stuff. It's like we can mine so much data out of there that really is helpful in terms of what really went on in terms of that phone and where it was and at what time and where it moved. That's all knowledge C database. And then she says, was there any information that you would wished you had had? She says, well, it would have been nice if I would have had the full the full system extraction from the first time he plugged in the phone. Like, I'll never get back. We'll never have the information that he lost when he just did the logical extraction. It's like we lost so much important stuff, especially the powering up and powering down information. Like losing that, which is critical. It's critical. I mean, that information was the key in the Murdoch trial to how they set the time of death for Paul and Maggie. Like that phone data was the case in terms of the murder side of it, not in terms of the financial crime side of it. But it was like, so, and they lost all that data. And so at that point, McClelland says, all right, can I ask a couple of preliminary questions? He's like, are you familiar with the Carroll County Sheriff Department or ISP resources and that they had it and what they had at the time, in terms of being able to do all this kind of stuff? She says, no, I'm not familiar with it. He's like, what about a drive-by study? Did you drive around and see what kind of cell service that you can get? He's asking her if she did a drive study, if she drove around to see what kind of cell service that she could get, or a walk around study, whatever the case you want it to be, whether it's on foot or whether it's driving around. No, I didn't do that. Did you do it? Because you are the ones who should have done it, not me. You should have done that. Did you do that? Like that would have been like if she was able to ask a question back to McClelland, that's what she would have asked. And then so he says, if Abby's phone, he says, so if Abby's phone or if Libby's phone had not been underneath Libby. Let me see. I fucking wrote that down. Hold on, bear with me. Yeah, my note taking today, y'all, not good. It was not good. It's like, to be honest with you, I got sucked into the testimony, and I was like 3 questions behind on everything, trying to like, oh my God, what did he say? And I got to try to write it down. I was like begging people for notes. I'm like, so yeah, my note taking not great today. But I want to see this thing where he says, so he says, if Abby's body wasn't on top of her phone, would the phone need to have been moved at 5:45 p.m.? If Abby's body wasn't on top of her body, or on top of the phone, I think she meant, would the phone need to have been moved at 5:45 in terms of the movement of the phone? And she said, well, technically no. Because what Nick was trying to get at was that if because he was trying to say that just the movement of taking the phone from underneath the body itself, does that create movement? And she said, maybe. I mean, not necessarily. It's like, and then he asked the same question about 1032. He's like, did the phone have to be moved at that point in order to get it underneath Abby? And she's like, well, I mean, in terms of like a step being counted, I mean, she's like, I don't know if just moving the phone up and down counts as a step. I don't think it does. I mean, I could do my phone like this for hours, and I don't know if it will. Let me see. I'm gonna actually test it. Let me see. You guys think that movement will create steps? Let me see if it does. I mean, because it is more of a swinging thing, right? I think that's how it does it. Let me see what happens. All right, so I'm gonna put steps on. I'm gonna start a workout. All right, so I'm gonna start it, and I'm just gonna kind of like move the phone around like this. Let's see if it starts counting steps. All right, so I'll do this for a second and see what it does. Oh yeah, it's counting steps. So I'm at wow, I just did 0.2 right there, just swinging my arms. So like just a movement like that, it's counting. Like, and once it starts, and then it catches up. Like it's still doing steps. Look, so I'm not moving it now. Oh, it finally quit moving, but it was like it was catching up. So if I do this and then watch, it'll eventually start catching up steps or not. Huh. Yeah, I don't. Oh, this case is insane. Um. So then about the concept of the phone in a vehicle, it doesn't necessarily log movement, and she says yes, it doesn't necessarily log movement, and that's where the whole conversation comes. There has to be like a bump, like if it's sitting on the armrest of your car or in your cup holder, and you hit one bump, like the consensus is that it has to be a couple of bumps in a row. That's one of the things where you've got no real data on it. Like there's no definitive answer on it. Oh yeah, let me turn on. That's what let me try. Let me see what it does if I turn on airplane mode. All right, so I turned on airplane mode. Let me see if it tracks. I'm going to do the same kind of wild movement with the arm, or just like I'm walking. All right, so let's see. I'm walking, and I'm connected to Wi-Fi in here. I'm walking. All right, there's our answer. Airplane mode, it does count steps, but that's on Wi-Fi. So the real question is, does it do it on, like, because I don't know if that do we think that steps requires a tower? Do you have to be connected either to Wi-Fi or a tower, or is it strictly GPS? Like, that's what I'm saying. Like nobody knows how this shit works. How can no one figure out how this shit works? Does anybody know? Nobody knows, right? I don't know. I don't know. I don't know. And neither of these experts know. And then so they get into the discussion about the bump in the car, but she says that it couldn't be one bump; that it has to be enough bumps to register motion. And then the question becomes like where I was asking, like if I hit a couple of bumps in my car, does it just continue? Does that trigger the movement to where it's going to, even if I don't hit any more bumps for the remainder of my drive home, is it going to continue as if that movement has started and now it's just tracking the mileage. You know what I'm saying? It's like, and no one can answer the questions. Um, and she said because it takes a while for her to realize it's in motion. So that was her. So all right, so then we get to the jury questions. They ask her first, why didn't you write your own report? And she said, well, frankly, I wasn't asked to do it, and frankly, I didn't have enough time to do it. So then they asked, could the iPhone have connected via sync to the iPad, to Libby's iPad? Like, is there a way that the iPad and the phone connected because they were synced together? So when the iPad's coming on, that it syncs and it's getting data from the iPad? She said, I don't think so. And she said that the iPad is going to have its own knowledge C database, and they're not going to share a knowledge C database. And then they asked this question: would water or could water or moisture affect movement? It's a great question. And her answer was, I don't know. So to me, that question was, all right, look, if the phone was wet, is it possible that it was not able to track movement because the phone had water damage at that point in time? It's a good question. And frankly, as you're about to find out, like after the jury questions, that concept is going to rear its head when Auger calls Cecil to the stand. And what was supposed to be a preventative move, but kind of backfired a little bit. It was interesting, but like it was the right move. There was no question it was the right move. But I'll explain it when we get there in like just a couple minutes. So they asked that question. And then they asked, would water affect the port? That's a great question, right? It's a great question. And she didn't know the answer. She said, I have no knowledge that it would. And then they asked the follow-up, could water, is it possible that water would not affect the headphone jack? And I guess, the question is obviously when they say affect, could it trick the phone into thinking that something went into the port if in fact it was water, if it's got water damage? And then they asked, is it possible that the phone was on silent or vibrate, in terms of why, or no, they said, could you tell if the phone was on silent or vibrate from the knowledge C data? And she's like, I think you can, but I didn't check for that. And she said that, she said, can you give us new information, or can you know Richard Allen's phone from his Google Pixel phone and Ting? Can you give us his last location? And she said, well, I wasn't asked to do that. And then McClellan asked a follow-up question. And he said, would you have needed his actual phone to get the historic precision location data? Because that was what they really asked. They asked, could you have gotten Richard Allen's historical precision location data? And she said, yeah, you could have, if Ting keeps it. Like Ting is his provider. And she's like, I don't know. She's like, I don't know if Ting does that. I don't know if they keep that data. So at that point, they ask about, are there other ways or other apps on the phone that can record movement? She's like, yeah, there are other apps that track movement, like WhatsApp does. And if so, do you know what apps Abby had on her phone that do track movement? And she says, I didn't look at for anything like that. I wasn't asked to. I didn't look at anything other than the Apple Health. And so that was it for her. So, I mean, to me, it's either going to be a huge deal to the jurors, or it's going to be a nothing burger. And I don't know which way it's going to be. I don't know. To me, it's a big deal. So, but like this, so this is the follow up. So this is what happens right after. So then we take the break. It's right around 4:00. The court, like obviously the gallery's a buzz. Everybody's, this is brand new info. This is shit that we have not known for 7 years. It's brand new. No one saw it coming. No one knew that it was coming. And boom. So we're all like talking about it. Everybody in there. And so when they get back in, so obviously what happens in the interim, and one of the things that's important to note is that they being the state, had asked for Bunner and Cecil to be allowed to sit in the courtroom during Eldridge's testimony in order to be able to prepare for rebuttal. So it was under the guise that the state would be putting Cecil and Bunner on to rebut her testimony in their rebuttal case. All right. And remember, rebuttal happens after the defense's case in chief, and rebuttal is limited to information that was brought in during the defense's case in chief. It's not a time for them to bring in evidence that they meant to put in their case in chief. So it's going to be limited to that. And yeah, geofence stuff is not coming in. That's not coming in. I actually thought the defense was going to rest today. So like I actually thought we were going to come up from the break and they were going to rest. But so at this point we take the break, and obviously there's time. And McClellan has mentioned the word rebuttal, and he has his two witnesses that he's going to use in rebuttal sitting in that room. Now I'm looking over at Chris Cecil, who's a nervous looking dude anyway. And this dude is shitting his pants, like unequivocally shitting his pants. Like you can see he is nervous as hell. He's sitting there. He's like watching this expert that just testifies much more cogently than he does. She seems to have a greater amount of knowledge about forensic cell phone data than he does. And he knows that he's going to be the guy that McClellan's going to put up on that stand to rebut her. He's not feeling great. So clearly the conversation for the defense team at this point is, all right, we don't know if she's going to force McClellan to go to rebuttal today, or we don't know if the judge is going to say, okay, I'm going to call it for the day, and then we're going to give McClellan and team overnight to go figure out how to rebut this shit. So they don't want that to happen. So calling Chris Cecil becomes the immediate decision as soon as they get back after the break. And the reason they do that is so that he is locked into saying, I don't know. That he doesn't have all night to go and try to figure out if there's an explanation about the whole port thing. They want to lock him into an answer. And then and so this is how it goes. So do you guys get why Ajay did that, or the defense team decided to do it? They didn't want to give him all night to be able to try to figure this out, see if there was some kind of rebuttal to the port apparently being plugged into and unplugged at 5:45 and 10:30. So at that point, the defense is like, all right, we got to put him on. We got to lock him into a position right now. We can't give him overnight. We want to see what this guy says right now. So she calls him. She calls Cecil. He gets on. She asks only 2 questions. She says, you've seen defendants pee, right? It's your log. It's your timeline, correct? He says, yeah. He's like, okay, do you see this part under Z where it says audio output start? It's like, do you know what that is? He says, no, I have no idea what that is. And this is after he sat in for her testimony. Okay. He's still saying he doesn't know what it is. And then she asks, um, she's like, do you know anything about the technology of how phones connect to the tower? And he says, no, I don't. It's not my training. It's not what I do. It's like, that's not my area. I have no idea about that kind of thing. So I don't know. So then McClellan gets up and he says, and this blew my mind. It blew my mind. Just blew my mind that this happened. So on the break, he's like, so McClellan asks him a few questions and he says, you researched the issue of whether something was plugged in to the headphone port, didn't you? And he's like, yeah. And he's like, what did you learn? He's like, well, he's like, I Googled water damage or dirt. Like, is there anything else that could cause a phone to think or trick a phone into thinking that it's in headphone mode? He says, so I Googled it. And he says that the searches I came up with are that water damage or dirt could cause the phone to register that something is plugged into the headphone jack or the port. And that's it. He's like, okay, I'm done. So Ajay's furious at this point. She's furious. She's absolutely furious. She's just so pissed off at this point. Just can't. So she's like, she's like, when did you do this research? He's like, did you do this on the break? He's like, yeah, I Googled it on the break. Because you know what happened, right? Nick McClellan was like, Cecil, you need to figure the fuck out how something else could have made that port go active. Like, and you need to do it right now. You've got 10 minutes. And Cecil's like, he's out there Googling. So she's like, oh, she's like, is it your normal procedure to, in a criminal case, to rely on Google searches for your information? And he says, no, obviously that's not my normal. She's like, it would be better practice. I mean, you rely on things such as learned treatises or scholarly articles, right? I mean, that's what you do. You know, like, please tell me that you're not going out there Googling shit like for your cases. And he's like, no, yeah, definitely. I want articles and I want, people that have done studies, and that's what I rely on. So it's like, you have to like imagine this moment in time where the jury is watching this develop, right? And they're sitting there watching the state that is in the process of trying to convict somebody of a double homicide, that in a case that didn't happen 6 months ago, it didn't happen a year ago, it didn't happen 2 years, that happened 7 years ago. And we are near the very end of the defense's case in chief. And their data expert, their phone data expert, is Googling answers to shit that they should have known years ago. This shouldn't have been a surprise to them. I mean, I don't know what you all are thinking, and I have no idea what the jury's thinking, but it's not a good look. It is not a good look. I don't even blame McClelland. Like, McClelland, I guarantee you, McClelland got in some ass after court today. He had all those dudes in a room and just lost his shit on them. They're the ones that have to supply. Like, Nick's not doing the research. He relies on his officers to do this shit. Like, this isn't his thing. Now, the counter argument is maybe the state should have done some depositions. They had every opportunity to depose all of the experts the defense hired, all of them. Just like the defense deposed over 70 people, which takes a hell of a lot of time. They decided, okay, you know what's important to us in terms of trying to get information, extract information from a lot of people, including everybody that they're going to have testify as an expert, is we're going to depose them because that allows us to go in under oath and ask those people all kinds of questions. You can see how useful it is in this trial, especially like Andy Baldwin loves refreshing people's recollection. He knows all of those transcripts like the back of his hand for every single witness that he has on the stand. So every time they don't answer some shit right, he's like, oh, well, I'm sorry to do this for the 15th time during your direct, but I have to refresh your recollection again because you just screwed up that answer. You said something different than you said during your deposition, and words matter. We have to make sure it's clear. We need to figure out which one's correct. Is it the one that was closer in time to the event, or is what you're saying on the witness stand right now? Like, let's figure it out. So, like, you see that the value of that. And the value for the state would have been had they decided to depose her instead of just doing one or two depositions total. Total. That's all that was done in this case by the state, in contrast to 70 plus for the defense. Had they deposed Stacey Eldridge, they would have known this information. This would not have been a surprise. They would have had time to prepare for it. So if it turns out that the jury's like, wow, you know, even though we think that Rick Allen might have done this, your investigation was so bad that we can't trust it. There is so much that you should have done that we can't trust your investigation. It's beyond shoddy. Why did they let the FBI walk right when they're starting to get into all the phone, like right before they're getting ready to make an arrest in August 21? They shit can the feds. Carter does. Like, how do you not go back to them when you've made an arrest in the case? When you get all of Allen's devices that we saw in the case in chief, when you've got Libby's phone, when you've got Cecil saying, "Oh, I'm finding new information," why are you saying, you know, Chris, that's a good job, buddy, but here's what's going to happen. We're going to take all this shit and we're going to let the feds take a look at it. Like now we need your help. I want you to think about that. Why would they not have done that? I mean, in terms of practically thinking about it, there's no explanation. Even if they're dismissed, you bring them back in. Like, you know, these aren't school kids. They're not going to be like, oh, you fired us. We're not coming back. They're like, hey, we need you guys. We got ahead of ourselves. My fault. We need you back. Would you guys come back? We got all kinds of device shit that we need you guys to do with all your money, resources, and tech. We need you guys. We need the best of the best out there doing this for us. That's a government agency. Come on in. Like, explain that to me. Can anybody explain to me that's not a shady reason as to why they didn't have them come back to figure all this shit out? Because I can think of all kinds of shady reasons. All kinds of shady reasons. I can't think of one legitimate reason. Is it as simple as, we wanted the credit. We weren't willing to, was it an ego thing? Was it like, oh, like if we let the feds in and they crack this shit, we're going to be standing behind them at the press conference and they're going to be the ones. I can't think of a legitimate reason. I can't. Because if that's it, that's sick. If that's it, and Allen is the guy and he's acquitted, then I don't know how they're going to look the families in the eyes and say, we're sorry. I don't know how that's going to happen. But it would have to happen. And it's going to have to be Nick McClelland. I mean, there's no way around it. You know, because this isn't a game. This is people's lives. This is serious. This is as serious as you can get. This isn't a joke. This is as real and serious as you can get in this world that we live in. And, you know, the one thing that's evident is that this investigation was for shit. And there's no two ways about it. They have the burden. It's their job to figure out all of this information, not the defense's. Defense has no burden. The defense could have said, you know what? We're good after the state's case is over. We don't think they proved their shit. We're not going to put any evidence on. And the jury could have gone back and deliberated and said, you're right. We agree. We think it seems like he could have done it, but you didn't prove it beyond a reasonable doubt. Because could have ain't enough. Might have ain't enough. Probably ain't enough. That's not beyond a reasonable doubt. So, you know, this whole concept of him going out and using Google just is a really, really bad look for them. And then he then asks, Ajay asks, is there any sign of water damage on the phone? She asked Cecil. And he says, I don't know. I never checked. And at this point, Ajay's pretty heated. She says, you're telling me. She says, well, first she says, so let me ask you this question. Who had the opportunity to check the phone over the last 7 years to see if there was water damage on it at any point? He says, law enforcement. He said, we had the phone. And she said, and you didn't do it. No one thought to do that. Even though your theory was that the girls had crossed the creek. No, that didn't dawn on one single person to check that phone to see if it had water damage, that maybe that would explain why movement stopped. Nobody thought that was a thing. Or dirt. Did anybody check for dirt? Same answer. And not one single person thought to do it. So ultimately, McClelland gets back up after that. He asks one question. And he says, he's like, isn't it true that Libby's phone was found under a shoe, under Abby's body in the woods? And he says, yes. Like, I mean, McClelland's like, they're like, he won't even bite on the concept that this phone left the premises ever. You know, I mean, and like I'm trying to figure out, I'm going to spend the night trying to figure out if that's possible. I mean, because like if the phone is in the trunk, is that metal enough? Say it's like let's just assume arguendo it's a 1965 something like a Comet, which, you know, back in the old days they actually used to make cars out of steel. You know, I would imagine that might block a signal pretty good, right? Yeah, that's a good point, athlete fitness. That's a good point. And I'm going to get to all the questions afterwards. So I don't like after that, they call Bunner, who was the first guy who did it. And she asked just a couple questions. And she said, so February 15th, 2017, that is the first time that you looked at the phone. He said, yes. Do you know what audio output start means? And he says, no. And then she says, did you Google search during the break? He says, no. And that was it for the day. So, I mean, we definitely got some interesting stuff coming in there. And I mean, everything else was interesting too, but nothing was as interesting as that. Like that was by far the most interesting thing that we got. So let's go back. So remember, I started backwards and I was moving forwards through it. And so Betsy Blair was the first witness that was called. As you'll recall, Betsy Blair was called during the state's case in chief. She is one of the eyewitnesses that was out at the trails that day. And she was the woman who took she did multiple loops around the trails. Like she would typically, her habit was to do 3 loops every time she went there. She went there several times a week, was her exercise routine. And on this particular day, she ended up having to go to the bathroom after her second loop. And so she ended up leaving and she went to the library in town to go pee. Now, if that seems crazy, I just want you to understand if you've never been to Monon High Bridge and the trails in proximity to the town of Delphi, it's a stone's throw. Like you're literally there in like 3 minutes. Like I can get from Main Street to the trails literally in 3 minutes. So it's very close. Because like I remember when we were first talking about Betsy Blair, people were like she didn't just like go in the woods and squat. I'm like, no, this isn't like there's a lot of people in there. This isn't that. This is not like you're in the deep woods and like the odds of you squatting over off the trail a bit is somebody's gonna walk by you. And Betsy Blair does not strike me as the type of person that is going to be caught urinating in the woods right off the trail. So no, like a civilized person, she got in her car and she rolled. So the difference is that this time the defense is direct examining her as opposed to cross-examining her. And they were very gentle with her the first time because they knew going in that she had information they felt was helpful. And I'm assuming that Allie went through the first thing that happened in court today, which was that the state had sought a limiting instruction with regard to the defense's false confession witness that testified second. Right. So she ended up not issuing the limiting instruction. And a limiting instruction is where she's basically saying before the testimony comes in, look, I'm going to warn you that these are the things that this expert cannot say. If this expert does say these things, you're to ignore them. So Rosie said, I'm going to go out and I'm going to read him the rule, which is 704B, and I'll make sure that he knows that he can't testify those things. So that happened. It was a motion that was filed early this morning or late last night. That was the first thing. I'm fairly certain Allie went over that. So I had emailed her that was something that she could go over. So Betsy gets on the stand and he's like, how many times and what times did you get to the trails that day? And like when did you go? She's like, I got out there. And like when she got out there didn't matter as much as when she left. So she had gotten 2 times around and then she left for about a half an hour. And she states that she re-arrived at the trails after she went to the bathroom at the library in Delphi at about 1:49. She gets back. And then at 2:14, she says that she left for good for the day. Now, she had established the first time how she knew the times because she has a Fitbit. So she knows her data. And at this point, he asks her, "So, how many cars were in the parking lot where she parked?" And she said, "Just mine." And she had parked at what she calls the niches entrance, which others call Mears, the Mears entrance, and what others call Sherry's Lane. So that's all the same thing for the most part. It sounds like there was some talk about the niches thing being a different area. I get the sense that they're basically in the same area. So she parks there, says there's no other cars there. So then she says she takes a left on 300 North, and Baldwin's doing the direct. He says, in what building did you pass? She says there was a business on the north side. There was a house on the left side, which would be the south side. And then she said, I saw an empty government building. And she said, and I have no idea what it is. And she said, I saw the entrance to the Andersons. And they says, well, let's go back. He's like, so the empty government building. He's like, do other people call it the CPS? Is that the CPS, old CPS building? She's like, I think that's what other people call it. And he's like, so what did you observe there? And she said, well, I saw one vehicle in that lot. And he says, okay. Do you have any reason to remember that particular vehicle? Basically, I have a couple of reasons. She said, one, it wasn't how other people park, meaning that they pulled in. She said it was actually backed in so that it was facing the road. He's like, oh, so it was like facing the road, like it was a getaway car, like somebody wanted to be able to get away real quick. This would be, the way to do it. You'd want your car facing the road, right? And she says, okay. And he says, what did the car look like? Well, she said the overall shape was, it was kind of boxy, it was angular. And he says, did it remind you of any vehicles? And she said, yes. She's like, my father had a car years ago when I was a kid, and it reminded me of that. And he says, what was that car? And she said that she thought it was a 1965, and I think she called it a Ford. And so does my friend Erica. She wrote Ford too. I think she inadvertently said Ford, but we know it's a Mercury Comet. And like I was kind of wondering, I'm like, is Andy gonna refresh her recollection? He didn't want to annoy her though, right? So he did not want to annoy her. So at that point, he says, do you know what color it was? She's like, I don't know what color it was. I just know that I said that it wasn't a bright color, that it wasn't red or yellow. And he's like, do you remember saying that it was not a black car? And she's like, I don't recall saying that. He says, well, it's like, this is something I have to get out. We need to make sure this is accurate. So I'm going to give you your transcript from your deposition back in 2019. And then I'm going to give you the page number and you can read it. She does that. He says, does that refresh your recollection? And then she says, well, initially she says it could have been black. And Andy's like jaw drops to the floor. He's like, what? She's like, oh no. She's like, I mean, it could not have been black. It was not black. He's like, oh, okay. But I literally saw he literally had to pick his jaw off the floor and pick it up. And then he says, what about a hatchback? Did it look to be a hatchback? She says, I didn't see the rear of the vehicle. Did you ever draw a rough sketch of what the vehicle that you saw for law enforcement? She says, I did. Of course, we didn't get to see it. No, she wasn't a hostile witness. She was not hostile at all. And she wasn't treated as such either. It was like Andy's very easygoing with most witnesses. Like the only witness he really ever had any kind of issue with was really Sarah Carbaugh. Like Sarah Carbaugh, he had but at least she was just unusual. She was a very unusual witness. And so he goes up to her. He's like, is this the drawing that you made? He's like, yeah. He's like, does that fairly and accurately depict? And she says, yes, this is my drawing. He moves it in to evidence, and it gets published to the jury. And then on cross, he says, did you speak to law enforcement on February 17th, 2017? She says, yes. And you said that you noticed a car closer to the building. Yes. And it was not new, right? Not shiny, right? And nothing really stood out. She says, yes. And she says, did I recontact you, talking about Diener? And she says, yes. And did you then add something? You said, yeah, it was an older model vehicle. And or she asked, she said, Diener said, did I ask you if it was an older model vehicle? And then Baldwin's like, wait a second. Like, is she going to be a witness on the case? Is like she going to get up there and testify? She's the one who told, she's claiming that she told her it was an older model vehicle. She's suggesting that she put that in her head. And so obviously Gold did not agree to put Diener on the stand. Because he asked, am I going to have the opportunity to put it on the stand? And she's like, no. She's like, I feel very certain about the shape of the vehicle and that it was older. And it's just like your suggestion did not change my memory of what I recall at all. And so she says, well, how was your vision in 2017? She's like, well, I wear contact lenses and I have them in all the time. And then jury questions, so that was it. So then the jury asked, is it possible that the car belonged to somebody that was working in the building? So of course they say no, that the building's been abandoned for quite some time. And do you know if anyone checked to see if it belonged to an employee? Obviously, there can't be employees because the building's no longer operational. So that's it. So that was Betsy Blair. And then we get to Dr. Stuart Gracian. And he was, like I said, he was really interesting. The guy's got like an impeccable CV. You know, he's from outside of Boston. Didn't have the accent though. I was hoping he was going to have that Boston accent. But the reality is that there's a high likelihood, like a very high likelihood, that the jury would hate him if he was in with a thick, like Southie Boston accent. The car, yeah, I'm talking about the jail. You know, it's like it would have been that whole thing. It would have been like watching like Karen Reed Light, but just with one witness. So Andy goes through. No, I'm sorry. Brad goes through. Brad Rosie does the direct. He does the goes through your typical thing that you do with your experts. Gets all their bio, and it says, you know, he's a psychiatrist now. He did his undergrad at Harvard. He got his master's. He got his doctorate at New York University Medical School. He did his residency at Harvard. He decided that that's not enough education, so he went and got his law degree, got his Juris Doctorate. He's on the faculty at Harvard, at the Harvard Medical School, and he's been there for 25 years. So the guy knows his shit. Like he's a legit dude. And so he's also he's got board certifications. He's on the American Board of Psychiatry. He's in good standing with the board. Yes, he is. Began being a psychiatrist in 1977. He completed his residency. His particular area that he really focuses on is he's an expert in solitary confinement, and that he really tries to focus on memory, false memories, traumatic events, and how those cause false memories. And in terms of the context, you know, he's looking for the psychological effects on a person of them being in solitary. Like, how does solitary affect people's memories and just their overall mental well-being? And he says that it's important to understand the effects of solitary confinement on people because it's commonly used in this country. And you know, he's like, it's something that he's had a passion for a long time. He's been a part of multiple class action lawsuits where they have been suing uh, government entities for cruel and unusual punishment and malicious prosecution, especially for pretrial detainees. So he said he's been, he was hired by the federal defender, which is basically who handles federal appeals. And, that he's worked with the BAU, the Behavioral Analysis Unit at the FBI, um, because they're trying to ask like who he works with. And as he said at some point that he was working with a cooperative defendant and that they started treating him badly. And so he dipped. He's done larger studies. He's evaluated several hundred people over all his years. So they get a copy of his CV in, which was defendant's MMM. And then they ask him if he's ever been published, and he's been published in many times regarding this area of solitary confinement and its effects on inmates. He was published in the American Journal of Psychiatry, which really caused a stir and ultimately led to change. And Brad asked him, well, what do you do on a daily basis? What's your daily day look like? And he says, well, I have a clinical practice in my house. I do forensic cases on psychology, effects of solitary. I do pro bono work in New York State for solitary confinement conditions. I give lectures. And of course, I'm over at the Harvard Medical and Law School where I give lectures a lot too. And then Rosie says, did I reach out to? He says, yes. And he says, okay, so what do we need you for? He says, well, Mr. Allen made some potentially incriminating statements. And did I offer you information? He says, yes, he did. He gave me a lot of information. Said I had Dr. Westcott's report, which, if you'll remember, was the defense's expert witness. And I also had other reports from the jail from Dr. Walla. I had the audio, I had the video, I had the phone calls. I had the reports from suicide companions. And that was all the stuff that I had. And that's what I used to evaluate what I was looking at. And he said I was basically focusing on the period of time from November 22nd through June of 23, or November of 22 through June of 23. Now, the info from January and February from Wabash Valley, I had that as well. And I looked at that through March of 24. And he said, is there anything that stood out to you? And he's like, well, yeah. I mean, the fact that Richard Allen was in solitary confinement for 13 months, that stood out to me. And he's like, well, what does solitary confinement mean? He's like, well, essentially it means that you're in confinement in a very small cell by yourself, maybe sometimes 8 by 12 square feet. That's small. You have very limited social interaction. You're enormously lonely. It's an isolating environment. They cannot maintain an adequate state of awareness when they're in that situation. And I saw all this in the videos. All of this was very evident to me in terms of Richard Allen inside of that cell, what was going on with him. And he says, when you reviewed the videos, what did you see? Well, I saw that he was in a very small cell. It was barren. He had a mattress on the floor. And there were mice droppings all over the place. And he's like, does that seem too dissimilar from other solitary cells? He's like, no. I mean, that's, there'll be varying degrees of bad, and this was on the higher end of bad. But, in my estimation, they're all terrible. It's a terrible thing to do to a human being. And then, so you saw the video, and you're also familiar with what the video shows, correct? He's like, yeah. He's like, well, I'm just going to tell you that the international standards on solitary confinement through United Nations is that 15 days of solitary confinement is the max that they're allowed to keep any prisoner of war or any kind of wartime hostage situation or prisoner situation. They can't keep them in solitary for more than 15 days. And then Nick objects. He's like, we're not talking about international. This is an Indiana case. And Indiana doesn't have to follow the rules of United Nations. It's like they can do whatever they want. And the judge is like, whatever, just let him say his thing. So he says, so what are the things that you've in your career that you've been able to document as occurring with people that are kept in solitary for extended periods of time? So you think, well, they become overly delirious, they're confused, they lose their memory of events, they begin to have no memory of what happened. In Rick's case, there was the smearing of feces, and that's something that's common that happens. You often see them nude with overtly sexual behavior. Like that's all very common that you see. It's a common theme that you see with people that are kept in solitary. And he says, so he's like, I've seen situations where you have people that have been seriously injured or that have killed themselves. And there's a 7 to 9 times higher rate of suicide for inmates in solitary than there are for inmates in Gen Pop. And then Brad asks him, so what's delirium? He says, well, it's the inability to maintain an adequate state of alertness. Everything floats by. Nothing makes sense. And he's like, what are the causes of it? Well, he's like, it can be internal, such as severe sepsis. He's like, there's also situations where there's just they're completely devoid of any kind of external situation or external stimulation, like inadequate. He's like, you see it in ICU psychosis. You'll see it with people that are having to be in an iron lung. It's inadequate. That there's nothing that's stimulating them. There's nothing that's got their thought process rolling. So it's one of those things that you see it with everybody that's in there for an extended period of time. It just warps their mind. Your mind can't function. And he says, did you see any indicators of delirium? And there's an objection. He says he has to limit the answer. He says, absolutely. I saw that he had the inability to remember anything. And if you remember, like, especially in the phone calls, you hear him saying, like, I don't know how many times he asked if he called his dad, who he had called like 2 hours prior. That was the phone call that we didn't get here from 3:13 a.m. And then he calls Kathy at 5:15 a.m. And he's asking her, did I call my dad? What did I say to my dad? Do you know if I called? And like on the next call, he's like, did I call my dad today? Like he's got no ability to remember anything. So he also sees that Rick Allen is frightened. He can tell that he's frightened, and he has doubts in his mind. And he's like, it's absolutely classic textbook, no doubt delirium that he was suffering from. So Brad then switches into false memories, which is really what we're getting at here. And he says that many people in many circumstances recall things that aren't true. And then he said that when we were doing our research, that we went back and tried to determine how memories happen. And he said that the biggest takeaway that I want you to understand from this, and this resonated with me so deeply because it's true. If you think about what I'm about to say to you, you'll realize what's true. He's like that memories don't start as images because you're not making the memory when it's happening. What memories start as are beliefs. And what those beliefs start as, they start from the first time you're thinking about the thing happening. Does that make sense? So when you're there, when you're in the midst of doing whatever you have a memory of, you're not memorizing it there. Like it's not a memory at that point. You're experiencing it. So when the memory of it starts, It starts at the first time that you have a memory of it, when you think about it for the first time. And whatever you believe happened at that point, that is what your first memory is going to be. He's like, he made the he says it's kind of like the game of telephone. So he's like, as soon as you like, if you so the next time you remember it, you're remembering the first memory that you had of it, which wasn't based on visuals. It was based on you thinking about what happened. So whatever mistakes are in there at that point are going to persist, and it'll change even more as you remember it. So, and then he says, he said, "Did you listen to Richard Allen's phone calls?" He said, "Yes." He said, "Did you see the symptoms of delirium?" He says, "Yes." He was hallucinating. Uh, I could see it. He was talking to himself. He was talking to things that weren't there. So, and with the false memories, so he said with real memories, with actual memories, that they're often brought about by the sense of smell or sight or touch. Like those things are things that will trigger actual memories. Like I'm sure that you guys have all like been able to recall things in your life based on a smell. Like there's a smell that you'll smell and it'll bring you right back. All right, so I mean, and that was kind of it for like uh he didn't have him on the stand for a long time. So Gracian was like short, but I think he gave people a pretty good idea of like how false memories are created, and that and like if you have a situation where you're not like because that didn't really address what happens if you're remembering something that you didn't even do. Like how does that come about? So on Cross, it was Diener, and she said, what were you provided to review?" And so he said, well, and one of the things that he said that all so I got to take it back. He did says that the false memories, when reviewed, or something that's reviewed repeatedly, if you're thinking about it over and over and over, or you're reading something over and over and over, that again they started as beliefs, not from visual. So she said, in this case, what were you provided that someone was reviewing repeatedly? And he said, I didn't give him anything. Like there was nothing. This was coming from his statements that he was making. And she says, so well, what did the defendant review repetitively or repeatedly? He's like, well, he's like, that's not what my study was about. Like I wasn't trying to figure out like what he used to form his false memories. I was trying to study him to see if he was in fact having false memories. And so she says when people were recovering real memories, that they typically would recall it from, again, sight and smell. So that's when that came up. And then so she asked, would a real memory, in terms of, would a real memory include things like in terms of the person being perceptive, such as insights, reflections on things, how things made them feel? Like, are those things consistent with real memories? And he's like, well, that's a different subject matter. And she was obviously getting at the Walla confession, where he says he got scared when he saw the van. She was trying to say, like, he was like, I was lying in wait. I saw the van. I got scared. Like those are things that he's claiming were something that were affecting him. And she's saying, isn't that indicative of him having a real memory? Like, can somebody have a false memory with that kind of layered detail where it's organized? And he's like, well, that's a different subject matter. And so she asked, well, what's the difference between what's the difference between a one man cell and solitary for safekeeping? And and he's like, well, it depends on the situation, and then so that would basically end at the cross. And Brad's like, well, regardless of whatever label, because that was one thing that really bothered me. Like I hope that it bothers the jury that they're trying to minimize, to downplay the fact that he was in solitary by calling it a one man cell. They're like, he wasn't in solitary. He was he was on suicide watch, and we were trying to keep him safe. He was a safekeeper, and we had to put him in a one man cell. And and like Rosie's like, I don't care what they're labeling it. Does the fact that someone is in solitary in a cell by themselves have a massive impact on a person's mental state and psychiatric state? And he's like, yes. It doesn't matter what they're calling it. They could try to couch it in whatever terms they want. The guy was in solitary confinement. Like I hope that the jury sees that for what it is. It's like soft pedaling the fact that they had him in these conditions is obscene to me. I mean, there's a lot of different reasons that they can acquit Rick Allen. Now, whether they do, I have no clue. And they may feel like if they're of the mindset that that casing is Rick Allen's, I mean, that might be the thing more than anything else. And at least one juror thought that because they asked the question. Like they were like, hey, you're aware that their expert said it was a match. What do you have to say about that? And you realize that she said that her work was verified by her supervisor. Like what do you have to say about that? Because he was, well, we'll get to him next. I'm going to be short with him because I want to get off. So then we get to the jury questions. Do you believe that the psychotic behavior can go back to normal when they are removed from solitary confinement? And he's like, yes, generally they can, but they're more prone to slip into a psychotic state. Once you kind of break that barrier of psychosis, especially when you've got this combination that Alan has with the depressive disorder, severe depressive disorder, and the anxiety. And then once you've kind of flipped that switch and you've been psychotic, he's more prone to slip into that at some point due to the same things. Like if he's experiencing extreme depression, severe depression, and anxiety, even if he's not in solitary, he could slip back into a psychotic state. And then the next question was, do you believe that a completely normal person can become psychotic after 6 months to a year of solitary confinement? And he said, absolutely. So that was it for those. So then they put on Aaron Warren. He was the third witness. This was a Rosie guy as well. Luttrell handled the cross. And so he basically goes through his background. He worked for Tennessee Bureau of Investigation for 6 years. He did that. He was a firearm and tool mark examiner for them. He has a doctorate in biophysics. And he's got his own company, which is SEP Forensic Consults. And then he left TBI because he had realized that, he was kind of like in the morass, and he was doing this thing where he's just out there, trying to, it's kind of making the donuts. And he was just kind of, like, I want more. He's like, I'm like a research guy. So at this point, I want to expand. I want to quit just being a research guy, and I want to get into it. I want to be able to get into what its passion is for me, which is researching. And so I wanted to get into, instead of just trying to figure out if this bullet came from this gun, I wanted to figure out what bullets do to the internal functions of the body. I really wanted to get in the research part of it again. So then he said that he's an esteemed member of AFTI, which, as we know, is the firearms. It's like the Association of Firearm uh, and Tool Mark Examiners. It's the big board. It's the main board. And then he says he's testified over the years for the state and the defense, and that he has gotten his training. That he's gone to many workshops. That he also trains firearm examiners. And then defendant puts in his they put it in his CV. And then he talks, and then Brad kind of slips into the concept of the critical community. And he's talking about when they had Oberg up there, because there's the battle going on whether or not tool markings is legitimate science, if that's something that we should be using to put people in prison. And he says, well, he's like, because you're a tool mark guy, right? That's what you did. So like you're well aware of uh, the fact that there's been criticism out there. And he's like, you're aware of like PCAST, the President's Council, and that there's these people out there, these detractors that are very critical of what you guys do. And he's like, yeah, I'm aware of it. He's like, and like, how do you guys handle it? He's like, well, we've actually found the constructive criticism to be helpful. We feel like because of that criticism, we consider it to be constructive, and it helps us up our game. Like we realize that once we can sit down and have an actual dialogue about what their critiques are, we say, you know what, you're right. Like that's something that we should try to like really tie up that loose end, or that's technology that we should really try to maybe start looking into, or yeah, these are issues with it that we should try to figure out a way to mitigate those issues so that this is more reliable. So he says that they use it in a positive way to help them try to, and they do it all through conducting studies, and through this use of doing studies, they're obviously doing all kinds of experimenting. They're really trying to critically critique themselves, and their goal is to try to prove what the critics are saying is wrong, and that yeah, you can trust what we do, and here's the proof of it. And through that process, that helps them further the field in terms of what they're doing, because they want it to be reliable. I mean, they want it to be something that's unimpeachable when you come in, and they want it to be like DNA, but it ain't that right now. It's not even close, you know. So he says, and then he asks for what he was able. He was retained, obviously. So what did he get? He's like, I got all of her microtelescopic images. I got the transcript of her report. Um, I got everything that she put together in terms of uh, her report in and of itself. So most of her data, and I was able to get the images themselves. Now the images will become a point of contention between Luttrell and this particular expert. And Brad asked him, he's like, was what you have from her enough to form an opinion? And he says, is there anything that you didn't get that you would expect to receive? And he said, no. And he says, well, so with the microscopic photos, what were you able to determine? He's like, well, he starts going through the process. And if you'll remember when Oberg was on there, she was adamant. She's like, I don't even want the jury looking at the pictures, because that only is used to refresh my recollection of what is in my mind. Because there's so many other things going on that one photograph is not reflective of what I based my opinion on. Like it's many other things. So he says, and he kind of goes into that. He's like, it's very important documentation. Like you really need that. So you have two experts here who have very different opinions on what's going on in terms of how important the images are. So, and he says, yeah, we use them to refresh a recollection. And he says that, lab accreditation is important because you want properly documented, so that another examiner can validate the work. That's why you take the images. The images are used in the event that another examiner for whatever reason, can't do a physical examination, you want your process to be documented so thoroughly that another examiner can look at it and do it from based on your images that you've retained in terms of documenting your process. He's like, that's critical. And he says, so we have to be able to illustrate the work, the process, the observations which led to the conclusion. So the work can be shown to the trier of fact. Like that's our goal. Like, because we didn't see that with Oberg, and I was surprised because that struck me as true. That struck me as something that was an actual fact that you would want the jury to be able to see your process. Like, it's one thing to get up there and say, I found that there was sufficient agreement between the test round that I fired and Richard Allen and in Richard Allen's gun and the round that was found at the crime scene. I found that there was sufficient agreement between the two. I'm willing to put my reputation on the line. I'm saying that it's a match. I can't say it's a match, but I'm saying there's sufficient agreement that I feel subjectively that round came from that gun. And the problem with her is she didn't show any of this work. I was telling you when we were watching it, I was like, when is she going to explain how she, like, her process, how she got to that? She really didn't do it. She really didn't, and I was like, man, I'm left wanting on this. But when we get to the jury questions, jury did not, well, at least one juror did not feel the same way. So he says, look, I typically like to think of the documentation through the photography as like a show your work situation. Here's the proof of what I did, and it's the proof that it's legit. And I just didn't see that with Oberg. I really didn't. Now, we didn't see it with him either, being fair, because he didn't do a physical examination, which ultimately, when we get the jury questions, they take a little umbrage with that. Like, why didn't you do it yourself? Like, why are you relying on the pictures? Couldn't you have gotten the shell, the unspent casing? Couldn't you have gotten Richard Allen's gun, or couldn't you have gone to where they had it and done the testing there? He's like, yeah, I could have. But that's not what I was asked to do. Now, again, you have a situation here, which I talked about earlier. The defense has limited funds for experts. And thus far, we've seen some pretty high dollar experts. I mean, we've got Stacey Eldridge, who charges $300 an hour. And I don't know, you could do the math. She was charged, and she said she worked 65 hours on her analyzing the data, and then another 15 hours. It's like they did not get a war chest for experts, so they kind of have to pick and choose their poison in terms of who they're going to have do what. And so when the defense asks an expert, like, okay, well, in a perfect world, we'd love to have you be able to do the physical examination so that you could just flamethrow it, but we're limited on funds. But they can't talk about that to the jury. Like, you can't bring that up. So now the jury's just like, oh, well, is the defense being shitty? Are they not doing the physical thing because they didn't want to get an answer that they don't want to hear? So they're relying on what we consider to be a less reliable form of investigating her work. So he says that, and then he starts talking about, the photographs and how important the lighting is. The lighting has to be just right. The angles have to be just right. The focus has to be just right, because what you're trying to get is the best pictures possible. And then he gets into the subclasses, and he talks about, but he's like, before we do that, let's just talk about like this inverted pyramid like this. He's like, so obviously the first thing that we have, and we should remember this from Oberg, you got class characteristics, which are everything in that class has them. It's like, oh, like I want an SUV, go into a car lot, you see SUVs, that's a class characteristic. If you look at a sedan, you say, okay, that's clearly not what I want to buy because I want an SUV, and that's not an SUV. So then you get into, then you skip from the subclass, you go into the individualized or individual characteristics, and these are unique identifiers. So, like the kind of the example he gave is like pretend like you have a buck knife. Okay, it's like your favorite buck knife, and you get it, you look at the blade, it's flawless. Say one time that you like drop it and it hits like a large slab rock and it causes like a chip on that knife. That your knife that you love now has this defect on it, which every time you use that knife, that defect, that mark is going to be left on whatever you've cut. Like if you have an examiner going to say, okay, well, I found this little V-like defect from when this guy dropped that knife, and I can see where he cut this steak right here, and I can tell that there's that V mark, that there's, because you're looking at it microscopically. So he's like, so that's what we're really looking for. Ultimately, at the end of the day, at the very tip of this inverted pyramid, that's the goal, to find individual characteristics. Within that, you have subclasses, and subclasses are things that we use to help reduce the field of potential weapons that it could have been. So they're not enough to make any kind of an agreement, but it helps thin the field. Like that's how you think about it. Class characteristics, like that's bare bones. And then you get down to the subclass, you could say, okay, this clearly isn't a Smith and Wesson. Like it doesn't have the same subclass things that we would see with the Smith and Wesson. So we could just take that out of the mix, and then you whittle your way down. So Rosie asked him about the relevance of the video that they showed him of the Sig Sauer plan. He's like, there was no relevance. It didn't show any of the actual making of any of the tools that would have related to the subclass. And then he talks about, he's like, well, or have there been any lab shut down recently because they cannot distinguish between subclasses even? Like not only are they not able to reach the level of individual characteristics, but you've got labs that have closed down recently because they can't distinguish between subclasses. And he's like, well, it's like, yes, actually the Rhode Island firearm examiner, like they're from the state police, they shut down. And he said the same thing with Wyoming. Those like recently, those two labs have shut down. So there's like actually labs that are closing down because they're not able to make those identifications even in the subclass level, which is a problem. So he says, getting to this, he's like, so we have an unfired round, which was ejected. And then, in terms of, so he was trying to explain, he's like, so what is an unfired round? What's a fire round? He says, so unfired round, like essentially what you have is it's ejected. So before you want to eject it, you have to remove the magazine. Okay. And then you rack the gun and it'll pop out. The ejector will pop it out. And so he says when a cartridge has been fired, obviously it's going to be different from an ejection because it's experiencing a high amount of pressure from the weapon. Obviously firing the weapon, the firing pin hitting the primer, and the gunpowder igniting. So he says, are you familiar with Exhibit 16, the unspent casing? He says, yes. He says, are you familiar with 314, Richard Allen Sig Sauer? He says, yes. Is it appropriate to compare a cycled round with fired round? He's like, well, no, due to the fact that there's pressure and time, those are the differences between the two. You've got just a completely different circumstance. He's like, I don't believe that it's appropriate to compare the two. He says it is done sometimes, but really, even when it's done, it's comparing apples to oranges as opposed to apples. And the question was, well, are you aware that Oberg was unable to make a sufficient agreement with any of the rounds that she ejected from 314, Richard Allen's gun? He's like, I am aware of that. And then he said, did she he said when she used the cycle, the test round to make her comparisons, was she able to use that? He's like, no. She ended up having to use the fired rounds to make the comparison. And then he says you have to prove that the marks, in terms of our goal as tool mark examiners, is that we have to prove that the marks are repeatable and reproducible. So that they're repeating and we can reproduce them. We want to see it over and over and over again, so that that's an apple to apple comparison. And that was not made here. So Rosie asked him about the error rate studies. He's like, have you ever seen any error rate studies regarding unspent round comparisons in terms of comparing them with fired rounds? He's like, no, there does not exist any error rate studies with respect to comparing unspent rounds being compared with fired rounds. They do not exist. So whatever the error rate they told you about, they don't know what it is with those two because no one's done a study on it. So he asked what the three tools are. He's like, the ejector, the extractor, and then the barrel hood. Then he said that Oberg took photos quite well of the ejector and the marks. He's like, not so much the ejector, but the marks. And he said that she also said that she had found a potential for a subclass from the ejector. He said, which I agree with. So that would have, he was in agreement that she had thinned the field. There were certain weapons she could have said, it's definitely not these. I think it's going to be one of these. He said for the extractor, he said he did the research and there was there a potential for a subclass? He said no. So the barrel hood documentation for the subclass, or the chamber face, which is that U pace shape that is the very first portion of the barrel. He says no. He's like, there was I never saw any kind of documentation that would support that there was potential for subclass match there. So Brad asks, is it possible from what you've seen for her work to make a determination of individual characteristics? So again, is it possible from what you've seen from her work to make a determination of individual characteristics? He says, not from what I've seen. So he said, I reviewed the 13 or 14 photographs, and he's like, you can see this triangular mark. It's the ejector mark. And he said, when you look at it through the comparison microscope, and you've got that hairline in there, that kind of black line that on the left side, you're looking at the round from the scene on 16, and on the right side, you're looking at the test fire from Richard Allen's gun. So you've got that comparison of the two. And he says, so what do you see with the light areas? He's like, well, the gross marks are the big lines that you can see. So those are gross marks. Those are the larger lines. Okay. And those are much brighter marks. And he's like, those are hallmarks of a subclass. So that's why I say that, I think that she did see enough to consider it to be a subclass. Now he says in terms of doing a proper analysis, I would then subtract the larger marks and I would look at the finer marks. Because if you're going to have any shot of making a true comparison, you're not going to do it from the larger marks. So, and I thought that this is important, and I don't know if the jury got it, because when I was looking at it, for as little as Oberg described the process, I'm looking at those three big marks, thinking that those are individualized. I'm like, and in my brain, I'm thinking like, okay, every Sig Sauer that has been built that was assembled in 2001 and came out of that factory, that shit's going to look the exact same. There's nothing distinguishable. That's just the the ejector that they use is going to leave those three marks. So this validated what I thought. I'm like, those are not individualized. But after watching Oberg, I didn't get that. So I hope that the jury was able to get this delineation from what this guy is saying, because he says what you're really looking at are the finer marks, the tiny little marks. He's like, because those are the marks that have the potential for individual characteristics. And he's like, she didn't look at those. She was using the gross marks. And then Rosie goes back and he asks him about, one of the issues with Rhode Island and why their lab closes. They had a difficulty distinguishing between the gross marks and the fine marks. He's like, yeah. And then he says, okay, objection. So then if you remember when Rosie was crossing, he was crossing Oberg, he had asked her a question about the CMS, which is the consecutive matching striations. So this is a different process that's been used. It's been around since like the late 50s, developed out in Berkeley, California. It's considered to be like a kind of a West Coast thing initially. It's now started to migrate. And frankly, a lot of the like AFD is like, I think this might be the better way. We think it's going the extra step. We think it's that thing that could help us as a field, having people feel more comfortable about the fact that it's a science as opposed to like an art. And so he says, you've got so he said CMS has become you got the standard, and you want a particular examiner that CMS has been used to silence critics, because the standard has been what it's been. You want a particular examiner to be able to say, all right, like, we've used this technique here, we've used the CMS, and we think that why we're going to start using it because it's going to help silence the critics. And the reason that they do it is because it's a numerical criteria that's used, where it requires a sequence of striations. And he says that in order to reach agreement, that there has to be either 2 runs of 3 striations or 1 run of 6 striations. That anything less than that is not going to be sufficient agreement. So it's like a numbers game. So you're either going to have 2 runs of 3, no matter if they're like in 2 different areas on the casing, or 1 run of 6. So they want to see that frequency and consistency. And then he asked, the preliminary question is, Luttrell says, are you aware that ISP does not use CMS? And he says, yes. So that will harken you back to when Rosie said, he asked Oberg, he's like, does your lab use CMS? And she says, no. He's like, so you would have to, so you don't use it personally? And she said, no. So he says that you would have to defer to somebody who does use it in terms of them having an opinion as to what the use of CMS has shown to that particular examiner. He says, I'd have to, because I don't use it. So he says, I just want to make clear, he says, CMS is not a different examination. He's like, some of the labs don't use it, but many of them are starting to use it. And then so he asks him, and this is all during a preliminary question. He's like, you don't use CMS, do you? He says, yes, actually I do. He's like, well, I don't see it on your CV. And he's like, it's actually there under my training. I trained with Dr. John Murdoch. And he's like, it is on my CV. He's like, it's under the training section. And then so he asks, has AFD recognized it? And he says, yes. And he says, because there is a subjectivity with respect to firearm examination, and everybody can form different opinions. Like two different examiners can look at the same thing and form a different opinion. So what we're trying to do with the CMS is to get rid of that. We want to try to make it where it's almost objective. So if you've got these either 2 runs of 3 striations or 1 run of 6, one of those 2 we consider to be the gold standard. At that point, if you've done that, at that point, we feel comfortable with you saying that there's sufficient agreement. If that does not exist, then we don't think that you should be saying that there is sufficient agreement. And then so Rosie's back on. He says, did you examine? So he's like, did you examine these images and apply the CMS standard? He says, yes, I did. He's like, and what did you find? He said, well, with the extractor, I found that there was one run of 4 striations. With the barrel head, I found that there was 0. And the ejector also had 0 consecutive striations. And so Rosie says, and so what is your opinion? He says, well, my opinion is that there is insufficient agreement. I don't believe that there was sufficient agreement. So therefore, I don't believe that that round was ejected out of that weapon. So there you go. You got your battling experts, right? So Rosie asked a couple more questions. He wants to address this issue that was brought up during a jury question. So I love when the lawyers are acknowledging these jury questions are good by they follow up with their own experts asking. So he gets into the fact about the slide. I don't know if you guys remember the jury question talking about the slide and whether or not it can be used with more force. And if you can use it with more force, will that create either deeper indentations from the ejector? And Oberg's answer was yes. And he says, so, in terms of firearm manufacturers, do they pay particular attention to the amount of force that you need to use on a slide? He says, yes. And he says, is there any research on that? He says, no. And he says, well, is there a way that, the slide become easier to slide? He's like, yeah. He's like, obviously as the slide gets broken in and there's changes to the metal surfaces that can cause the slide to rack more easily. He's like, but it's really a speed thing as opposed to a force thing. It's like, I don't think it's because you're doing it harder. It's like, I think you're doing it faster. So that's what might, he's like, but there's no way to measure it. It's like not a measurable thing. It's not repeatable. So it doesn't really have that much of an impact in terms of what we try to do. So Luttrell goes on cross, and he's like, he basically decides to hammer the guy by cherry picking things that he has done in other cases and things that he said on other interviews or in writing or what have you. So he says, you've been known to say that firearms examiner is the equivalent to a mechanical fingerprint. You said that, right? He's like, I have used that. I have said that previously. And he said, you did no written report in this case. He says, correct. He's like, why not? It's like, defense didn't ask me to. He's like, they asked me to review her work and see if I agreed with what her analysis was and her opinion. And he says, so tool marks can persist for up to 5 years. He said, correct. He said, a subclass or family characteristics is a way to whittle down the field of possible tools. He says, yes. And the relationship of the extractor and the ejector would that be a primary class characteristic? He says, yes. And he said some tools can be used on multiple different weapons, like meaning we've got tools, you can have ejectors made by a third-party vendor, and they can be used on different weapons, correct? He said, yes. He's like, and so we also have tools that are made by the CNC machine, and those can be used on different weapons within the Sig Sauer print, like different models. He's like, yes. And so he's like, I just want to be clear that different tools are made by different machines. He says, yes. Like the ejector and the extractor and the extractors are definitely made by different machines. He's like, but then you have machines that make multiple tools. He's like, there's one machine that will make, the slide in the frame. And so he says, and then he establishes that many of the tools that are found in the weapons are made by third-party vendors. And he says, yes. So then he starts going into, he's like, so you were a fire examiner for TBI for what, 6 years? And he's like, you have any idea how long Melissa Oberg's been doing this? He's like, yeah, it's a substantial period of time. He's like, okay, so are you aware that Miss Oberg had concerns about the ejector regarding a subclass? And he says, yeah, correct. She said that she found a subclass, the ejector. And did she articulate any concern about the extractor or the barrel face? And he says, no. He's like, what? Like at this portion, Luttrell just lost his shit. Like he was so upset, or super, super upset, because he couldn't get the answer he wanted. Like Luttrell, if he had knowledge that she had found concern about potential subclass characteristics in either of those other two tools, the barrel face or um, the extractor, then she should have noted in his report, because he was very solid on saying she didn't note it in her report. So I don't know what to tell you. So he was like, "What? Like I don't know why, if she had it in the report and he could have basically impeached him right there, why he didn't do it, but he never did it." So he's like, "So you have to admit that Oberg has way more experience than you, yeah?" He's like, "Does AFD encourage their examiners to conduct research um, uh, based on their knowledge and using photographs, or do they prefer when they do a physical examination?" He's like, "It's both. It's like physical examinations and the use of the microscopic images are both recognized as valid." So he's like, "Are you suggesting that Oberg just quit or just forgot to put information about a subclass characteristics of the extractor and the barrel face?" I'm like, "Yes, that's what I'm saying. She didn't put it in a report." He's like, "You don't do that either, do you?" He's like, "Well," he's like, "if it's a specific case that I'm researching and it doesn't have anything to do, like they're not asking me about the extractor or the barrel face, then yeah, I won't put it in. But this wasn't that. Like they were trying to get, a match here. They were trying to get sufficient agreement. So she was asked to look at everything, and she did, but she didn't put it in, so I can't tell you anything about it." So he said the fact that she notes three different tool markings, does that strengthen her opinion? And he says, "No, it doesn't. And the bottom line is a tool mark is a tool mark, correct?" He's like, "No, that's not correct." And so he says the test fires can be appropriate for sufficient agreement. Isn't that true? He's like, "Well," it's like, "I disagree. I don't think that they can be. I mean, there's just too many different circumstances in order to trust it." He said, and he said, "You did that with Exhibit 00. And he was talking about a case that he had, or he said, "You did that with the defendant's Exhibit 00 or OO. Um, so, and you said that you could tell that they were tool marks." He's like, "Well," he's like, "I was not talking about the gross marks. I was talking about the finer marks. And on the finer marks, I don't find that they're individualized." He's like, "I don't think that there's sufficient agreement." And he says, "Do you actually use CMS, correct?" He's like, "Yes, you do." So he tries to impeach him. He's trying to impeach him on this forever. He's like, so you've said in the past that CMS is a West Coast thing. It's not for the Midwest." It's like, "Yeah, I definitely said that when it was first, kind of making its way to the Midwest." He's like, "But, he's like, it was developed out at Berkeley. So that's factual. It was a West Coast thing, so they were really using it out there, but now it's started to migrate." And he says, he's like, "Were you ever trained to use another examiner's photos to reach a conclusion?" He says, "Yes, I was." He's like, "As a matter of fact, we're all trained to use other examiners' photos. Oftentimes, that's all that we have." So he's like, "You can use another examiner's photos to testify in court about your conclusions?" He's like, "Yes." He's like, "And that's frequently done." He's like, "Have you testified um, that you cannot reach a conclusion based on photographs alone?" And he's like, "Yeah." He's like, "In the Flagstaff case, I could not use the photos alone, but that was a completely different situation." So this is a point where he's looking at other times where he's testified in cases and he could not make a match based on photographs. So he's trying to say, "Look, everything that you're doing here with the photographs, okay, well, when you did it over there, you said that photographs weren't enough." So he's trying to catch him in that particular. He's like, "But it's different scenarios, completely different scenarios." He's like, "Those pictures sucked. And that's not what we were looking like. The things that we needed to try to find sufficient agreement with weren't included in the photograph. So I couldn't use photographs. I needed to use the microscope." So he spends an inordinate amount of time trying to get him to say what the most important tool in his lab is. So he asks him, "What is the most important tool in firearm examination?" And Warren says, "Myself." He's like, "Oh, this guy. He's like, that son of a bitch." So then he says, "How important is a comparison microscope?" And he's like, He's like, it's critical. It's critical for making a comparison, but it's not required. He's like, so he's like, so you're saying that you can use it or not use it? He's like, well, yeah. He's like, there's other tools you can use. You can use, for instance, a 3D microscope. All right. And so then Rosie gets up. So that was basically it. He didn't make a bunch of headway with them, but he kind of like tore them down a little bit. It may have been effective. So Rosie says, he asked you everything. He's like, did you have everything that you needed in order to make to form an opinion here? He's like, yes, I did. And you didn't ask for the round or the gun, right? He's like, no, I was asked to review the document. He says, so physical examination is something that I offer, right? And he's like, and we didn't ask you to do that, correct? He's like, and I do it all the time. It's like a 50-50 thing. It's like half the time I'm doing physical examinations, half the time people want me just to do the documentation review. So he says, take it or leave it. Would you have used your comparison microscope if you had been asked to use it? He's like, yeah. He's like, I would have used it, yes. In this particular circumstance, it would have been helpful. And then he asks him, did you make yourself available for deposition by the state? And he says, yes. So then we get to the jury questions, and they are, so the first question was change in position of the tools. Can that change the marks? And if so, how does CMS distinguish that? He's like, yeah, I mean, the change of position can change the marks, and CMS. He's like, it's pretty cut and dry. If it makes the run, if it makes the two runs of 3 or one run of 6, then it doesn't matter if it's changed, because as long as we get the consecutive marks of the striations, then it like CMS, like that's kind of the point of CMS. It's like that's why we need it. It doesn't matter if they've changed, because you're always going to get those 6 marks, no matter if things have changed over time due to other circumstances. And then they asked, would cleaning, disassembling, reassembling, could that change individual characteristics? He's like, no, not unless something similar to like the buck knife comparison happened, like somebody dropped one of the tools which caused a defect, then that would change it. And he said, then the question said, was there an actual full photograph of the ejector? He said, no, there wasn't a full photograph of the ejector, not like a proper full photograph of the ejector. So they're already kind of like picking at him, like, all right, well, you didn't even see a full picture of the ejector. He's like, that's right, but in terms of like seeing the ejector, it's not necessarily relevant to determining, because whatever that ejector looks like, that it's what left the marks. So he could certainly, like he doesn't necessarily need to see the ejector itself. But I mean, it doesn't matter what we think out here. It's like this is the stuff that's going through the jurors' minds. So he says, he's like, do you know if the manufacturer keeps track of subclasses? Which is a good question. He says, no. He says, is there a reason you didn't conduct your own physical test? Well, good question. He says, I was retained to review the documentation. That's what they requested me to do. And they said, could you have done a physical analysis? And he says, yes, absolutely. I do them all the time. He said, would doing your own physical analysis have been more conclusive? He said it could have been. It could have been more conclusive, where I could have come in and absolutely said, she's dead wrong. Not only do I not, like, instead of me just saying, I don't think there's sufficient agreement, but if I had done my own physical examination, I could have said, okay, she's absolutely wrong, and this is why. And I could have shown it to you guys. I could have showed you my work. So yeah, I mean, that's for sure. And then they asked the question, is 2 runs of 3 or 1 run of 6, is that what's considered the gold standard? I said, yes, that is. And they said, are you a certified firearm examiner? He said, yes, I am. And then Luttrell asks him, certified by who? He says, AFTI. And then he says, could manual cycling be cause lighter or darker marks depending on force? So that was basically the same question they asked Oberg. He's like, that's where he says, I think it would be a matter of speed, not force, and more for the extractor than for the ejector. And then he says, then they ask the question, do you look for subclass markings on the cartridge itself from the manufacturer? He's like, yeah, I do, but that's much harder to do because of the size of the lots. He's like, and I cannot tell from the ejector picture whether or not those subclass markings on the cartridge were reliable enough to report on. And then they asked, can a photograph be as effective as a comparison microscope? And then he says it can be. It can be. It depends on the quality of the photographs, but they can be. It's like, I'm telling you, we use photographs all the time to make comparisons. Because in theory, you're taking a photograph that is supposed to be exactly what you're seeing with your naked eye and through the microscope. So if you can take that picture with the lighting that's just right, which they're all trained to do. Again, you're trying to document your process. You have to be able to show your work. You can't just say, okay, especially like how I was confused thinking that the gross marks were the match. I'm like, it seems like every single SIG that uses that ejector is going to leave those marks. What's distinctive about those? And she just didn't explain it well. So he said, are you aware that Mrs. Oberg, so this was one of the questions I was like, ooh. So are you aware that Miss Oberg's findings were verified by a second individual? And he said, yes, I am. He says there's 3 different types of verification: semi-blind, fully blind, and then blind. And then he said the problem is that you want no context clues. And he said, with respect to the fact that the ISP lab, they're only expecting verifications if you have sufficient agreement, and that is a context clue. So like the fact that person is in there verifying, they have a context clue by the mere fact that they're doing it in and of itself means that he knows without her saying it that there was sufficient agreement. It's like in a perfect world. And Oberg said the same thing. She's like, I would like it where like this thing, like nobody knew anything. Like they're just coming in, they have no idea. Like that we make it so that we have to do all of them. Every single thing is validated, no matter what, whether it's agreement, insufficient agreement, whatever, that they look at all of them. And then that's how they validate. So they don't have those context clues. And then somebody asked the question, what's his, Luttrell says, you're familiar with Mark Kiesler. That's the guy who did the validation. He's like, yeah, he's part of ISP. And he's like, yeah, he's like, what, he's like, was he involved with AFTI? He's like, yeah. He's like, what was he? He's like, oh, he's the past president. And then he says, are you aware that the extractor has a recessed groove that was showing individual characteristics? And he said, yeah, it's not really an individual characteristic. It has this groove. Like I'd consider that to be more of subclass. And then the last question they ask is it normal practice for you not to prefer or to prepare a report? And he says, yeah, it's 50% of the time. And the reality is it's the money. That's what it is. It all depends on the cash. So that was it. So, again, you've got your battle of the experts. You've got one examiner saying match or sufficient agreement, and you got one saying non. So I don't know. But I can tell you tomorrow, I think that this thing's coming to an end. I think we're going to get rebuttal. And then depending how quickly they do that, there could be closings tomorrow. I have a feeling that we're going to get closing arguments on Thursday night or Thursday during the day. All right, so we're down to 960. I always lose so many, which is depressing for how long I've been following this case. It's the note taking. It's like bullshit. It's like that's why it sucks that it boils down to note taking. I just can't take like Fast notes. I do the best I can though. All right, so I want to go through, see if we got any questions. Sarah Brown, appreciate you. Thank you so much. Welcome to the family. Cool lady coming in with 5DD memberships. Appreciate you. How does the jury seem to be taking defense expert opinions? I mean, it's hard not to respect them because of their, they're really, they're highly qualified, and if you're balancing the qualifications of both sides experts, I mean, clearly the defense has more on paper, substantially more qualified experts. And like, I mean, they're hearing these guys testify on the stand, and it ain't pretty, in terms of, because they're the same guys who are doing the investigation. So, I would think that they'd be like, wow, these defense has some pretty good experts. $10 holler from Help Save the Music. Thank you, thank you, thank you. Cool lady. Gold prosecutor, law enforcement need to spend 1 month like RA, assuming in solitary. That would learn them. Kendall, thanks for everything you're doing, Bob and Allie. Appreciate it, Kendall. Thanks for that $2 holla. George King, gifted 1 DD membership. Oh, thanks, George. You're awesome. Nay, gifted 1 DD. Appreciate it. I assume there's a cam video of the date and time that Dr. Walla stated that he gave her the confession about the van. Now that we know the camcorder has audio. So, yeah, I don't think that they were taking camcorder videos of the sessions, though. I think that was like they would transport him. But I'm not 100% on that. We didn't get to see him. So I don't I think that I got the impression that they showed him in there. I don't know why they wouldn't have had him on that particular video and audio. So that's actually a really good question. Really is. One that I don't know the answer to. Like, if they filmed that entire thing and if they caught the sound, seems like that would be something that the state would want to put out just to prove that Walla didn't make this shit up. What physical evidence Libby left behind is the smoking gun. The bridge guy video is Richard Allen. It looks like him, in my opinion. I mean, we'll see. The jury may agree with you. I know people hate to like this response, but it really does look like about every dude in Indiana. It's true. If I were to walk down the street, I could point out 50 bridge guys to you in like a 15-minute walk around the courthouse. It's just, it's just like a portly white dude wearing jeans and a Carhartt or like a blue jacket and boots, the head covering. I mean, I don't know. Okay. I thought the Kirchhoff expert would say what junk science it was. I mean, damn, they could rule out 2 of the guns of the neighbors. Yeah, it's like they didn't, because he does the same thing. So that's what really Tobin was going to be. And if you'll remember, Tobin was their expert, who was the metallurgy guy that was going to come in and say it was junk science. So they were going to try to cover both bases, and then Gull shut him down. So Jason McClellan, Australian, $8 holla. Was there any evidence that Libby's phone was accessed after her death by the killers? Depends. Both girls' fingerprints could open it. I mean, like, I consider somebody sticking something in those aux ports to be somebody accessing the phone. So yes, phone, cart before the horse. For later, don't confessions usually come up with a barter? Who gets a bottle of anything in a Supermax solitary cell? It's true, and that that's what I've been saying. And thanks for the $5 holla. It's like, to me, it would have been that secondary gain that they were saying that he was malingering for, like that he was lying about, that he was psychotic, when I think the reality is that the prison and Walla and the guards would have been using secondary gain, like, hey, you want to get out of this shithole? Just admit you did it. Hey, you want to see Kathy? Admit you did it. Like that. Like, that's all you have to do, dude. You just got to say, I did it. And then when he starts saying I did it, they're like, dude, like, you got to give us a little more. Like, it's got to sound realistic. You can't just say I did it. They're going to reject. You know what I mean? Like, that would be the kind of the process of it. So thank you for that. His first pet. Thank you so much for that $5 holla. I'll refresh my memory. Was his house searched before or after the bullet was discovered? After, long after. Is it possible it was in airplane mode, or did it start going off towers again by itself? I don't think it was. I mean, if it was in airplane mode, that would explain it. That would be potentially an explanation. but we don't know. We don't know if it was in airplane mode. I mean, it's certainly possible. Rebby Lee, $10. Hey, Bob, thanks for your coverage and being there. Appreciate you. Appreciate your stellar coverage. I appreciate you, Rebby. Thanks. New member. Thank you. Thank you. Thank you. Gene, thank you so much. $4 super sticker. Moon Goddess, what if they put the phone in some aluminum foil potato chip bag to block the signal? I mean, if that works, that sounds more feasible to me than somebody like a killer having a Faraday bag. That's for sure. Tammy, ISP Doug Carter, please expand on the tentacles of the case that you have investigated over the past 7 years. You and Delphi have produced a single dead garden worm. Please explain. No doubt. No doubt. Thank you for that, Tammy. Now there are signs outside the courthouse stating that nobody can line up until 7 a.m. I saw that. I guess they're doing that because we're getting close, very, very close to closing. So, and they know that's going to be madness. So, can you all do Bob a solid and hit the thumbs up? Yes, please. Thank you. He's working his ass off to cover this morning cover this case morning and night. Yeah, I'm like done, y'all. I got to get this thing over with. I'm fried. Idaho Charlie, $5 holla. Those old phones can have the SIM card battery taken out. Did they check? Doubtful. I doubt it. Like, I mean, based on what you're hearing, does it sound like they would be doing that shit? They didn't even check phone damage for water, like water damage. So yeah, phones do have something in them that detects water damage. Was it? They didn't check. They did not check, Taboo. So no jury said, just let them answer. I didn't hear it. And I asked Andrea, she didn't hear it. So I know some people are trying to say it, but I didn't hear it. That doesn't mean it didn't happen. Like I was under the impression they like yelled it out like during the testimony. I don't know. So I'm dying to hear the jurors' questions or facial reactions. So you did. Does the state deny this happened? I'm not sure what you're talking about. Oh, you're talking about the plug-in? I mean, they were surprised by it. So I mean, yeah, I don't know how you can deny it happened. I think that they have to try to give the alternate theory, which now their alternate theory is that, the phone was wet. But like, how can the phone be wet at 2:30 when that's when they would have crossed the creek? And then it doesn't do that until 5:30, 5:44. Does that seem plausible to y'all? Because that's what it would have to be. I mean, they're locked into their timeline. So does that seem plausible? Like that's what the real analysis is. Can the phone have been submerged at 2:28 or 2:30, and then it just sits there for 2.5 hours, and then at some point the water causes it to go into headphone mode after 2.5 hours instead of immediately? Somebody take your phone and test it. Anybody with an old iPhone, why don't you power it up, do the test? We'll put it on air tomorrow. PDF photography, it's not proven that they died at 2:30. I agree. So they could not have been in the area. They could have not been in the area when the thing was plugged in, brought back, and killed there in the night. No question. Thanks for the $5. I mean, that's the whole attack on the timeline. What time does Rick's alibi start? We haven't heard it, to be honest with you. I mean, like I kept hearing things that they were like having him at the house at like 3:11, but I mean, if his like we haven't gotten any evidence of where the hell he was yet. But I don't know if it's coming. Any of the local barns outbuildings have metal roofs? Unsure. I'm sure they do. Many barns have metal roofs, especially older type barns. Do you think they will get to closings tomorrow and Thursday? If I had to give my best guess, I think tomorrow is going to be. I think the defense will probably feel like they have to recall Eldridge in order to combat this whole concept of the wet phone causing the plug-in. It's like the defense is like so excited about this thing that their expert uncovered, and then Cecil goes out and does a Google search during the break and like tampers all the excitement. So like they're gonna have to put Eldridge back on, I would think, in order to counter whatever he came up with during his little Google search. If the van was the big reveal, did law enforcement say they looked at all vans in the county? No, they definitely did not. Jason's back with another $8 Aussie Love. Yes, this was an iPhone 6. What are we up to now? iPhone 15. Yep. Maybe even 16. I don't know. Rick H, it still doesn't seem to exclude the Faraday shield theory, all metal van compartment, boot, trunk, or specialist Faraday bag. Surely this is good for the defense argument if the jury understands this. I guess. Yeah. I mean, like, and you got to convince them that the killer was that prepared going in, that this thing was something. So do you think the defense went in heavy with the Odin stuff to distract the state from the real case? I mean, I can't discount it. I think they actually wanted to go in on it. You know what I mean? Like, I think that they thought that it was legit. I think that they thought that those individuals were actually involved. I know that certain cops did. Kevin Murphy, Click, Ferenczi, they all thought that those guys, the old holders in the fields in the Westfalls, Johnny Messers, that those guys were a part of this. So, $20 haul. I developed iOS apps since 2011. You started a workout instead of letting the phone motion sensor collect the data. Great point. That's a great point. The app is allowed to override how Apple would normally collect STAP data. All right. Thank you so much for that, Athlete. That's a great point. Because you're right. I did start it. So it knows to try to collect the data because I'm asking it to. It's an excellent point. All right. So, Audrey, would a mailbox made of metal produce the same results of a block signal? Better Call Saul made me think of putting one. It's true. It's true. Yeah. I mean, that's true. Chuck was very much about you better stick your phone in that shit. Don't bring that phone in my house. And that's what he did. He stuck it in the mailbox. So, Jer, $5 Canadian stupor. Thank you, brother. Appreciate it. Kraken, all net sales of my art piece, Justice for Abby and Libby, go to their scholarship funds. And for Kathy and Rick, a prison reform design available post trial for separate funds. That's awesome. Go to the Real Booty shop there. Guys, check that out. Kraken does great work. And Kraken's like a true homie. So I'm glad you're on here, Kraken. Promoting. I'm all for it. Jessica Gilman, $10 holla. I was in solitary for months 10 years ago. I'm still traumatized specifically. Oh my God. Like, I saw people thanking you for this, Jessica. I didn't see it at the time. I'm still traumatized, specifically remembering not wanting to leave my cell because it was physically painful to feel wind, water, and hear sounds and such. Yeah, I mean, like the sensory deprivation is a real thing. It's a real thing. So thank you for that. Thank you for that. For months, 10 years ago, still traumatized. It's brutal. Athlete Fitness, do we know the battery level of the phone when the girls were discovered? They don't. Like, they lost that information when he got he did the initial logical extraction instead of doing the full system extraction. Like, we would have had it then. All we know is that it wasn't dead because it came back on at 4:30. I'm super behind where Bob says Apple NDAs must be thorough. I worked in a building that also housed Apple IT customer service. I had to sign an NDA just to work in the same building. That makes total sense. Forrest gifted 5DD. Thank you. Thank you, Forrest. Bob, love you, dude. Love you, Pokey. Thank you so much. Angela, thank you for all you do, Bob. Appreciate you. Bear down. Don't get me depressed. Gifted 10DD podcast memberships. Thank you, Don Burke. Always giver. Appreciate you. Long time, bigger first time live chatter. Matt props to DD for years. Appreciate you, MM. Appreciate you so much. Thank you for that $10 holla. Shiraz, our folks that came in later, tell us what you saw regarding the jury. The purportedly yelled at McClellan. I didn't see it. Hopefully, you guys gave Shiraz a nice primer. Like, I heard people saying, I didn't see anything like that. But like, if it was possible, like when the jury's like leaving the room, they shout back, "Let the expert!" It's like, maybe I didn't hear it. JAK, I'm not convinced Bridge Guy had anything to do with the murders. Thanks for covering the trial. Appreciate you, Jack. Thanks for $5. WB, $10 holla for your time. Appreciate it. Thank you so much. Robin, problem with Bridge Guy is he looks like any middle-aged chubby dude. Agreed. Like I'm not saying that to like say it's not true. I'm just saying like I don't know how people are sitting there saying it looks like the dude. Like it looks like tons of dudes. You can't see his goddamn face. All right. I know I got some Venmos, so I want to give some Venmo love. Let me check here. And then I am calling it, y'all. Okay, so I know that I owed a huge thank you to Sherry. Sherry M kicked me down with 100. Allie and I with $100 Venmo on the 4th. Thank you so much, Sherry. That's so incredibly generous. It brought a tear to my eye. And Jolene, always giver. She's just been killing me with kindness. 22 times on the 4th while she's sitting in line doing yeoman's work out there. I'm actually glad that you guys can't get out there till 7 so y'all can get some sleep. But I mean, you guys have to give we have to give you so much credit for like I'm lucky because I have a reserved seat. Like I haven't had to go through the nightmare. Like, and I'm exhausted. I'm exhausted. Like I'm absolutely exhausted. I could not even imagine if I was having to deal with the line shit. It's like it's brutal. So you guys are the real heroes, the ones out there doing that line sitting like on the arm for free. I mean, that cannot be understated how heroic y'all are. Kate S with a $25 holla, Megan P with the $25 holla. I think I gave that love yesterday. Tiana with a $50 holla today. Appreciate you. Janine M, $10 holla. Appreciate you. And Hannah L, $5 holla. Appreciate you guys. You guys are amazing. I'm so grateful to all y'all. Let me check the Cash App, just make sure. Okay, so I got a couple Cash Apps. I got one from Kathy K, $30 for for your advice. Thanks for all you and Allie do. Appreciate you so much, Kathy. That was really thoughtful. And then our always giver, Pammy, $20 for again, excellent contact. Take care of you today at 9:17. Thank you so much, Pammy. I love you. All right, to my mods, you guys are amazing. I love every single one of you. You are just spectacular human beings. And I know like you guys are working your asses off. And I am so grateful to all of you. And the channel's growing. So I know the work is harder for you. We're getting bigger crowds. So I thank you guys so much for everything that you're doing on the daily, not just one time, but multiple times a day. So you guys are my heroes because you guys are just absolutely crushing it out there. And I think that you're probably doing a great job. I unfortunately, when I'm going through it, I can't watch or see the chat as much as I'd like. Because you guys know, I typically like to really engage in the chat. But it's like I've been going almost 4 hours tonight and I just never even got to see the chat. Really. I'm sure it was great. So, all right, you guys, make sure please to share, like, subscribe. Share, like, subscribe. All three of those things are free. All three of those things help the channel grow. And we think that we have some pretty good content. I've been missing Babe. Like, I wish she was on with me, but she's got stuff she's doing. Plus, she's taking care of everything at the homestead. So I ain't sweating her on it, but I do miss her. I like the back and forth. So, but I'm probably a little quicker getting through the deets, but maybe not. It's like 4 hours either way. It doesn't really seem like it. So, all right, you guys are the best. Because remember, without y'all, I'm just an old man talking about a bunch of cases. Talking.